check, check, hello, hello. Check, 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 check. Check, 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 check. ഇങ്ങനെയല്ലേ എൻ്റെ സെറ്റിങ്? ഏ ചെക്ക്.
Hello, check, sound check, check. Check, check, look, check. Check, check.
Good morning to all. Shall we begin today's session? We have, may I request Justice G. Radharani of the Telangana High Court to come to the dais and to moderate this session. Justice Charlie, Justice Arun, Justice Anu, and Justice Babu. Please come to the stage. Today we have two eminent judges of the Kerala High Court who have contributed seminal jurisprudence in the field of sexual offences and generally in criminal law. Justice Vijay Raghavan and Justice Vechu Kurian Thomas. And we have also responses from the delegates also thereafter. And if possible, we'll announce after this session as to whether we can have the photograph session immediately after this. Because if we have it as a last thing, probably many may leave. If the Honorable Chief Justice of the Kerala High Court arrives here by 11:30, probably would like to have the photograph session immediately after this session. And maybe we have drafted a resolution in terms of yesterday's deliberations. That also probably will formally take it up towards the last part of this session. So over to the resource persons and the moderator.
Good morning, everybody. A warm welcome to the second day of the Regional Judicial Colloquium on PoCSO Act, Juvenile Justice and Drug Abuse Among Children. May I humbly invite Honorable Mr. Justice Shaji P. Chali, Judge, High Court of Kerala, and the Chairman of the High Court Juvenile Justice Committee to deliver the welcome address.
A very good morning to all. We are on the second day. Yesterday, we have all attended a very effective and fruitful discussion and deliberation. Among us, we had eminent speakers right from the inaugural session. Justice Ravindra Bhatt addressed us on various nuances of the law that we are deliberating. Honorable Chief Justice of the High Court of Kerala has also addressed us. Thereafter, very effective discussion was made by the resource persons. And at the end of the day, we are quite confident that we have all acquired immense knowledge and the shortcomings of the acts in question. Today's topic is restructuring justice delivery process relating to children in conflict with law and offenses under the PoCSO Act, an agenda for changing the mindset. Our speakers are Justice Raja Vijayaraghavan V, who will be handling the topic relevance of forensic evidence and evidential burden in child abuse cases, and Honorable Mr. Justice Bechu Kurian Thomas would be handling the topic necessity of victim-centric approach in PoCSO Act cases. We have eminent Justice G. Radharani, Judge High Court of Telangana, to moderate. Apart from that, we have Mr. Sadish Kumar V, Judge PoCSO Court Perimbau, Srimati Priyanka IAS, Director Women and Child Development Department, Government of Kerala, and Mr. Dharmendra Kumar Meena, IPS, Director of Forensic Science, Government of Karnataka. We all know that the introduction of the PoCSO Act as well as the Juvenile Justice Act are the outcome of various deliberations and discussions that have taken place in the international level, and the resolutions and conventions adopted by our country on the basis of the conventions that are adopted in UN various resolutions starting from 1966 onwards. I don't want to take much of your time because we'll have to keep the timelines since many of you will have to leave immediately after the lunch. So we will have to keep the time, including the speakers. We will have to give more time to the speakers so as to have a wholesome approach and understanding of the issues. I'm sure that we have two eminent judges of the Kerala High Court, revered judges, who were handling as lawyers and judges varied subjects, including criminal laws. And they have rendered various judgments on the topic, and they are quite passionate persons so far as the laws in question are concerned. I'm sure that this is going to be a brainstorming discussion, and all of you will sit and enjoy. And at the end of the day, we will have to find that we will have to pass a resolution about this so that the government can take up the matter, the parliament can take up the matter as to whether any amendment is required to the law, where any, a new law is required, and all those things will have to be deliberated and come through in our discussions. It's a journey, in fact, a journey. We have started some time back from the introduction of both the acts. Various deliberations and discussions are made at the national level. And I think this is my 6th year as a judge, as the chairman of the Juvenile Justice Committee, to participate in such conventions. And yesterday I find that it was a very interesting deliberation among us, and especially the resource persons who are very passionate in the subject, and many of them who have worked in the field and has seen pictures and the difficulties faced by these victims. So that I move on to my duty to welcome the resource persons as well as the delegates from various states. From bottom of my heart, I welcome Justice Raja Vijayaraghavan and Justice Bechu Kurian Thomas to the 4th session of our regional colloquium. I also welcome Justice G. Radharani, who is moderating the session. Mr. Satish Kumar V, Judge PoCSO Court, Perimbaur, Srimadi Priyanka G, IS, as well as Dharmendra Kumar Meena, IPS, to this session. I welcome from my bottom of my heart, on my personal behalf as well as behalf of the High Court of Kerala and the PoCSO as well as the Judge Committee, all the judges from the 4 states, the judicial officers who are present here and attending the function online, and also the government delegates from the 4 states. Thank you very much. Jai Hind. I hope you'll have a wonderful session. Thank you.
Thank you, my lord. We are to commence the 4th and final session of the colloquium. The moderator of the session is Honorable Dr. Justice G. Radharani, Judge, High Court of Telangana. The theme of the session is Restructuring Justice Delivery Processes Relating to Children in Conflict with Law and Offences under the PoCSO Act, an agenda for changing the mindset. The first speaker of the session is Honorable Mr. Justice Raja Vijayaraghavan V, Judge, High Court of Kerala. It is pertinent to note that His Lordship, in a recent judgment, has asserted the need for setting up of sufficient number of modern forensic labs in order to speed up the justice delivery system and thus facilitate to curb the unacceptably high acquittal rate. His Lordship is on the dais to address us on the topic Relevance of Forensic Evidence and Evidential Burden in Child Abuse Cases.
Good morning. It is in fact a very, very great honor for me to be here. In fact, if you go through the brochure, you will find we planned this session in such a manner that after the introductory remarks of Justice Charlie, these 2 speakers, that is Justice Bechu as well as myself, we'll speak for about 30 minutes on 2 topics. Thereafter, we'll have a short speech by Satish Kumar, because I've made it a point, because Satish Kumar has been a PoCSO judge for the last 2 years. He's been dealing with cases in and out. So I'll be, interacting with him. Probably other judges who have enough experience can also interact. And we have also Priyanka IAS, the Director of Women and Child Development, as well as Dharmendra Kumar Meena, the Director of Forensic Science Lab, Department, Government of Kerala. What we want is a true interaction with all these stakeholders so that, we can come out with certain things. As far as I am concerned, what I am trying to do is I'll just, I've structured my presentation in such a manner that though it may sound very basic, I'll just take you through the various provisions of section 29 and 30. And my attempt is to, place before this great August gathering the difficulties and the dilemmas faced by the counsel who appears for the accused, the judges who deal with PoCSO matters, as well as the prosecution, because of the so-called reverse burden put under section 29, as well as the section 30 of the PoCSO Act. We'll also discuss briefly as to at what point of time this presumption comes into play, as to whether presumptions can be applied in bail applications when it comes up before court, at what, whether it is after taking of cognizance. All these aspects we'll just try and ponder over. in the next 30 minutes. Now, if you can see the slide, Section 29, I just want you to go through very carefully, because I'm sure all of you are, have gone through 1,000 times, but then we'll just point as to Section 29 as well as Section 30 and understand the subtle difference between two provisions. Now, where a person is prosecuted, the word used is prosecuted, for committing or abetting or attempting to commit any offense under Section 3, 5, 7, and 9. These are the most graver offenses, like aggravated penetrative sexual assault and etc. The special court shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. This is Section 29. The 3-4 sections are clearly noted, that is 3, 5, 7, and 9. Now, when we come to Section 30, as you can see, there is mention about the mental state. In any prosecution for any offense under the Act, which requires a culpable mental state on the part of the accused. As you can see in Section 39, this culpable mental state has not been mentioned. Only in Section 30, the culpable mental state of the accused is mentioned. The special court shall presume the existence of such mental state, but it shall be defense for the accused to prove the fact that he had no mental state, with respect to the act charged as an offense in the prosecution. And explanation is there about culpable mental state. We need not look into all those aspects at this particular point of time, but I just wanted to point out that insofar as 29 is concerned, the mental state of the accused is absolutely irrelevant. But insofar as 30 is concerned, it has some relevance. Now, I've just mentioned, we have mentioned Section 3, 5, 9, etc. 3 is penetrative sexual assault. A person is said to commit, no voluntary, no sexual intent, nothing is mentioned. Aggravated penetrative sexual assault, who a police officer, it starts with that. And aggravated sexual assault, who are being so and so. So what I intend to say here is that mens rea is not made essential. The legislature may make exceptions. This is with regard to the peculiar nature of the offenses. We have similar provisions in the Narcotic Drugs and Psychotropic Substances Act, the Negotiable Instruments Act, the Prevention of Corruption Act, etc., etc. This is the gravest, the most odious offense a person can ever contemplate is one under the Protection of Children from Sexual Offences Act. That is exactly the reason why, insofar as 29 is concerned, only 3, 5, and 9 is mentioned. Now, sexual assault as well as sexual harassment are the two offenses where the sexual intent of the accused is made. This is because these are acts which may be done by a person innocuously and without sexual intent, and may be misunderstood to be acts of sexual harassment. Therefore, the legislature has said this act should be preceded with some mental element. Now, let us come to Section 3. This is purely basic, I know that, but then I'll have to just, in order to go to the next step, I'll have to say that. Section 3 means proved. That is, a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it exists. We have other not proved and disproved, but then the problem here, I am just highlighting the word proved is because after interacting with some of the session judges, I got the feeling that at what stage of the proceeding, in a trial proceeding before the court of law, the exact import of the word proved should come into place, because I'll just go to the next step, and so that you will get a better idea of that. Because in a prosecution under the PoCSO Act, some interpretational decisions are there. I'll just take you to that after this. Anyway, I'll just take you to burden of proof and then come back to proved. So burden of proof as well as evidential burden are the two things that we need to bear in mind in PoCSO cases. The legal burden that is the burden of establishing the bundle of facts constituting the guilt of the accused is always on the prosecution. Absolutely, it doesn't move. But the evidential burden, that the burden of proving the existence or non-existence of one or more facts in issue, is on it can shift from the accused to the accused as well. I rely on a judgment of just the Supreme Court. In a criminal trial, the legal burden lies upon the prosecution, and that burden never shifts. And notwithstanding the same, the evidential burden, namely the burden of proving one or more fact in issue, may be laid by law upon the accused. What happens in a criminal court is, from the stage of bail application, contents are taken before the court, saying that it is for the prosecution to establish its case beyond the shadow of reasonable doubt. We just need to sit tight. We don't have to do anything about it. Some of the judges take the view that Section 29 is always there. The police have registered a crime against you. Now that Section 29 is there and Section 30 is there, we will presume that there is some responsibility on your part, and that you can't just go scot-free in any other offences under the IPC. Let us assume a 326 matter or any other provision of law where there is no reverse burden like in Section 29 and 30. Every accused will come and say that no, you can't use 29 and 30 at the stage of bail application. A lot of dilemma is there with the session judges. Even in trials, after the basic foundational facts are proved by the prosecution, a contention is taken by the accused. After cross-examining the witness, they are able to bring out chinks in the prosecution. The witness speaks about date of incident, time of incident, the injury sustained. It wavers. The accused will definitely take a contention that even the foundational facts, you need to go to the extent of the court should ascertain whether it has been proved or not. Some judgments would say, no. One David versus State, a single judge of this court said, only a prima facie case, like you don't have to interpret or you don't have to weigh the prosecution case and the contention of the accused prior to 232 of the CRPC. In one judgment of Justice Ajay Bhanod of the Allahabad High Court, he said, no, even if contentions are taken, all those things are there. You need to ascertain whether the prosecution has been able to prove the essential facts. Only then the burden will shift to the accused. That dilemma is there for the session judges. But then I would just like to say that legal burden is always on the prosecution and the evidential burden may shift. Now, I'll just take you all those. I'm sure you're aware of Section 101 to 106 of the IPC, Indian Evidence Act, 105 and 106 of some relevance. Now, 105 says the burden of proving that the case of the accused comes with the exception is on the accused. The burden of proving fact, especially when the knowledge, when any fact is especially within the knowledge of the person, the burden of proving that fact is upon him. 101 to 104 will be on the burden of the part of the prosecution itself. Now we'll just rush to may presume and shall presume and conclusive proof. The may presume, the discretion is left to the court. Shall presume, now here the discretion, both are rebuttable presumptions, but then the discretion is on the liberty of the court is limited. So there is one thing called conclusive proof as well, but then conclusive proof as per the Evidence Act is concerned, we are concerned only with 112 of the Evidence Act, which speaks about illegitimate children as regards the conclusivity of judgments in 41 and 42 and cessation of territory or something in 113. Nowhere else is conclusive proof mentioned. Now we come to the biggest dilemma faced by the judges. Now, the principle which is being followed from time immemorial is that a person is to be presumed to be innocent until he is proven guilty. Superficially, now this is what Justice in Noor-Agha, the Honorable Supreme Court said, offense may be incredibly ugly, it may be diabolic, but then it may even shake the conscience of the court, but that doesn't mean that the valuable rights of the accused should be ditched. And it is also settled that the suspicion cannot be a substitute for legal evidence. Then we need to go to presumption of fact as well as presumption of law. I narrate all these introductive remarks just to conclude, as to come to the final conclusion as to what stage Section 29 and 30 would apply. Now I'll just take you to presumption of fact and presumption of law. Presumption of fact, it's in respect of a specific evidence, assumes existence of another fact that has been directly proven or established. Discretionary presumption and can be challenged by presenting evidence that contradicts the inference being drawn. As far as principle of law is concerned, it's a legal principle. Assumes a certain fact is true regardless of specific evidence in a case and can be rebutted with evidence to the contrary. Now, let us come to the dilemma that is being faced by the judges. Now, everybody looks upon 2008, that is our Bible insofar as the presumption is concerned, the reverse burden is concerned. Supreme Court said, just as S.B. Sinha said in 2018 6 SEC, where any statute provides for presumptions to operate against the accused, then the duty is on, to prove the guilt of the accused beyond reasonable doubt, and the accused's duty is only to prove the innocence only on a preponderance of probability. Now, this is where the difficulty arises. Now, let us assume a prosecution case in which the allegation is that the witness, the child was subjected to some abuse as defined under the provisions of the Act. Now, what happens is, the child enters the box. Let us assume a case in which just the child is there. Nobody else is there. But the evidence of the child is sterling. The basic fundamental facts I'll just show you is that the fact that that proof has to age. The child will probably the prosecution will put up evidence to show that the child was under the age of 16 or under the age of 12 or whatever, or under the age of 18. The child will get into the box and say, was subject to an offensive act. And the child will point to the accused and say, this is the man who committed the offensive act. And there'll be medical, forensic, or cyber evidence to prove some act on the part of the accused, maybe some pictures, maybe chat manuscripts, maybe messages. These are the foundational facts that are to be proved by the prosecutor. Let us assume that those things are proven by the prosecution, or basically at least the child enters the box and gives that particular evidence, which to the satisfaction of the court is good enough to go to the next level. Now what happens is, after the foundational facts are proven, now the burden now shifts, the evidential burden shifts to the accused. Now it is for him to let in some sort of an evidence to controvert. Let me say at this particular junction that if all these 4 facts are solidly proved by the victim concerned, that is the age, then it's absolutely next to impossible for the accused to let in negative evidence to show otherwise. But there may be situations in which maybe the child has not passed matriculation, or the child does not have a certificate to show that, or that there are chinks in the prosecution evidence with regard to the offensive act committed by the child. Then it was for the accused, probably the accused at the time of evidence, or maybe after the stage of 232, the CRPC will raise contentions that this child cannot be believed. And to what extent is the issue? Now, in A.S. Krishna, and State of Madras, the Supreme Court said, whenever presumptions are employed in a statute, there should always be a reasonable relation between the offense and the presumption. Presumptions are to be raised only when the facts mentioned in the provisions are established by reliable evidence. What exactly is the reliable evidence? That is left to each and individual judge with this vast experience. He'll be able to analyze the evidence of the child and come to a conclusion. Yes, this is like he'll sit as a prudent person and come to the conclusion that this is believable and that we need to go to the next stage. Presumption can be raised. The investigating officer is duty bound to extract reliable and cogent evidence relating to the facts mentioned in the statute to give rise to the presumption. Now, this is one very, very great quote that I've seen. It is mentioned in some of the judgments as well. Presumptions are bats in law. They fly in a twilight, but vanish in the light of facts. Now, the child comes up, gives some sort of an evidence, the presumption applies to presumption applies, and immediately thereafter, the accused uses a torch, points out certain aspects which chinks in the prosecution case, and it would vanish in the light of facts. This is the only manner in which the accused, somehow or the other, can get a reprieve. Now we come to the foundational facts. Now I've just mentioned about foundational facts. This is something which we got from M.G. Agarwal in 1965, and it has been continuous as such. A foundational fact that is in a prosecution case, in an offense under the PoCSO Act, is a fact from which other facts would be inferred from. A caution that should be taken before deciding on the admissibility of a foundational fact is that the inference from a fact requires to be true, safe, and correct, and should be drawn based on any fact that has been proved. Now, and I said about foundational facts, if these foundational facts are proven by the prosecution, like I just mentioned, that the proof as to age was subject to an offensive act, it was the accused who committed the forbidden act, and medical forensic reports of the injury caused, then the ball is on the accused court to prove it otherwise. He'll have to let in some sort of an evidence to the satisfaction of the session judge or the PoCSO judge to unsettle the presumption that comes to the rescue of the child or the prosecution. Now, what is the effect of Section 29? This is I'll come to this, and because it is almost 10 o'clock, I'll just take you through this and conclude. Now, presumption of guilt under section 29 would be capable enough to add strength to the case of the prosecution and would support the evidence provided by the prosecution. That presumption of guilt will always be there. The statutory presumption in the PoCSO Act creates an exception to the ordinary rule of innocence, puts the onus on the accused to rebut the presumption and establish his innocence. When foundation is laid by legally acceptable evidence, incumbent upon the accused to establish from the evidence on record that he has not committed the offense. How can he show that? He can show from the circumstance of a particular case that a man of ordinary prudence would most probably draw an inference of innocence in his favor. The accused, how can he do that? Accused man can adduce defense evidence. He can discredit prosecution witness through effective cross-examination and expose patent absurdities or inherent infirmities. I just mentioned this because in order to unsettle the presumption under 29, there is no necessity that he should enter the box or let in concrete evidence or anything. He can bring out the patent absurdities in the prosecution case, and then he can say that I am entitled to an acquittal. The presumption does not take away the essential duty of the court to analyze the evidence on record in the light of the special features of a particular case. Only redeeming feature in a trial under the PoCSO Act is that the prosecution is additionally armed with the presumption and the corresponding obligation on the accused to rebut the presumption. Now, in David versus State of Kerala, a learned single judge said, the highest burden should always be on the prosecution and lower on the accused, as he can prove his innocence by pointing out the patent absurdities and inherent deformities. Now, these are some of the case laws I've come across. Nu Raga was the state of Punjab and another. That is the basic and fundamental judgment everybody uses as Bible to understand what reverse burden is and what the responsibility of the prosecution is. Prosecution has to prove its case beyond the shadow of doubt. The accused can use, even by preponderance of probabilities, he can try and unsettle the case. He can bring out patent absurdities as well. Some of the judges have a conception, some of the judgments also say that. Now, whether the burden cast upon the accused to unsettle is beyond the shadow of reasonable doubt, or is it with, by preponderance of probabilities. But no Roga, the Supreme Court has said, accused, the burden is not so high as the prosecution. He can seek rescue in the principles as narrated therein. Now, next is Jarnail Singh versus State of Haryana, that is AAR 2013 SC 3467. In this case, Justice Kehar noted that insofar as the PoCSO cases are concerned, like in the Juvenile Justice Act, determination of age, there was no provision. Therefore, the Supreme Court said, the rules of 2007 as well as the Juvenile Justice Act provisions can be imported. There are three manner in which the age of the victim can be determined. Then State of Bihar versus Raj Ballabh Prasad, this is Justice Sikri's judgment with regard to consideration of the application of section 29 in bail application. It doesn't say much, but it only says that when section 29 is there, the court should be much more cautious. Justin alias Ranjit versus Union of India, that is 2026 KHC 546, a judgment rendered by Justice Sunil Thomas in a petition challenging the constitutional validity of the presumptions under 29 and 30. After looking into all these provisions and all these judgments, Justice Sunil Thomas said it is constitutional. And he has also mentioned as to which are the foundational facts, what are the burden cast upon the accused. Very, very well written judgment by Justice Sunil Thomas. David versus State of Kerala is 2025 KLT 92. That is rendered by Justice P.B. Suresh Kumar. Almost similar aspects. Justice Suresh Kumar was of the opinion that in a sessions trial, the opening case of the prosecution under 226, he can be discharged 227. He said, after letting every evidence and after reaching the stage of 232, if the courts decide to go forward, then the burden would be cast upon the accused to say otherwise. Now, next is Dharmendra Singh versus State of Justice Delhi High Court judgment, very well written judgment. I think everybody can use Dharmendra Singh to consider the relevance of presumptions and everything. That is 275-2020 DLT 49, Justice Bambani's judgment. Then this is one recent judgment by Justice Ajay Bhanot of the Allahabad High Court, that is Monish versus State of UP. He has also looked into the relevant aspects with regard to the presumptions and very, very well written judgment. He was of the view that these are the circumstances under which Section 29 would come into play. And Joy VS was the state of Kerala. It is by Justice Pishareddy. He also considered as to how, in a bail application, the scope and import of Section 29 of the Protection of Children from Sexual Offences Act. Now, I'll briefly, before closing, I'll just say that insofar as forensic evidence is concerned, we have a director here. The difficulty which is faced in Kerala is that we have forensic and chemical examiners lab. High courts have taken up the matter and have issued directions to the state government to set up chemical analysis labs and forensics labs in all districts and even mobile labs in the district, so that reports are received at least a 15 or 10 day specified period within the court. As expeditiously as possible. Insofar as cyber evidence is concerned, you'll know that now the Supreme Court has come up with the judgment in Arjun Pandit Rao. I say that the judges are the gatekeepers. At the time of framing of the charge itself, the judges are supposed to look into whether the certification is there. If certification under Section 65B is not there, it is for the judges to inform or take appropriate action to ensure that the accused is not given a reprieve, because in almost all 100% of the cases, the tower dump details, the messages, the WhatsApp chats, etc. is produced. Therefore, the importance is much to ensure that all evidence, as far as possible, is brought on record. Then, as regards more medical evidence and forensic evidence, it is we should ensure that all these evidence come before the court. An analysis lab like vaginal swabs and everything, we should ensure that those reports, I understand from my session judges that the most difficulty faced by them is with regard to receipt of reports from the medical reports as well as analysis reports. Our intention and our purpose, and the director has also assured that all districts have come up in all forensic labs have come up in all districts, but their difficulty is manpower. Our target and basic objective, because as per the PoCSO Act, it should be finished off within 1 year, I guess, and the reports and everything, it should be finished off, and therefore it is our endeavor, our exercise to ensure that all these reports reaches the courts as expeditiously, not even 15 days, as soon as it is received. If private labs can come up in all nooks and corners, I don't understand why in such a important legislature and statute, why the state government is reluctant to come up with labs in all districts, and mobile labs should also be there. And I hope Mr. Satish will be talking for 10 minutes with his experience. Probably after Justice Bechu's talk, maybe we can have an interaction with all the session judges, and you can tell us exactly what the problems faced by the session judges while reckoning Section 29 and 30. Thank you very much for this time.
Thank you, my lord. The second speaker of the session is Honorable Mr. Justice Bachu Kurian Thomas, Judge, High Court of Kerala. The judgments delivered by His Lordship are marked by the views on the approach to be taken towards the victims of PoCSO cases and the need for a child-friendly judicial process. In a recent judgment, His Lordship has issued very detailed directions to be included in the curriculum of the State of Kerala and the CBSE, which highlights the inclusion of a prevention-oriented program on sexual abuse as a mandatory part of the curriculum. May I humbly invite Honorable Mr. Justice Bachu Kurian Thomas to share the thoughts on necessity of victim-centric approach in PoCSO Act cases.
Distinguished moderator, Justice G. Radharani of Telangana High Court, my sisters and brother judges, the other dignitaries of the days, and friends. Doing an activity after Justice Raja has always been an uphill task. Be it cricket, be it badminton, be it lawyering, be it judging, and today I realize that even speaking is also an arduous task after Justice Raja. He has got an inherent charm to captivate the audience. So, with the limited potential and abilities, I'll try to do my best. I know I am called upon to speak on a topic or speak on an aspect of PoCSO, which would be like taking coal to Newcastle. Most of you handle this act day in and day out. And my experience, apart from handling few cases as a lawyer, is about 9 months of handling the jurisdiction of PoCSO matters in a bail court. The necessity of a victim-centric approach in PoCSO. All along, we have had the victim in the periphery and the offender or the accused in the center. It was only in 1996, while interpreting Section 326 of the Code of Criminal Procedure 1973, which stated that the trial shall be open in open court, the Supreme Court sounded a note of caution and said, in rape cases, it must be in-camera proceedings. The reason, then stated in 1996 by Chief Justice Anand and Justice Sagir Ahmad, assumes relevance and significance even today, because they said, their lordship said, for a victim to come out and give the best evidence possible, she must feel secure and confident. From then on, the thought process started working in the legal minds. Till then, it was the NGOs who were crying for having a victim-centric approach in legal matters. Finally, in 2008, after Justice Malimat Committee suggested reforms in Criminal Procedure Code and gave a right of appeal to a victim by amending Section 372, the first input in a statute came in, giving some importance to the victim. Thereafter, the NGOs cried foul still. And finally, we have one of the finest pieces of legislation post-Constitution. As I traversed through the different sections, I realized that they have not left any stone unturned, except for the future, for catering to future requirements. Most of the requirements for a victim have already been incorporated into the statute, which is, in a comparison with other legislations, is really marvelous. And while contemplating on what to speak today, especially with an almost identical or similar theme having been spoken to by ground level stakeholders who's got real experience, I was reminded of what my senior in the law profession told me years ago, that despite handling a particular type of case for 50 years and more, he used to read that particular provision of law every day morning before that case, because he was told that you get a new input every day. With this thought in my background, I also came across an experience that one of my cases, my office had to handle, where we had an experience where a PoCSO court came to the conclusion that the victim, in the judgment it is mentioned that the victim is lying. It was hard for us as lawyers to digest that statement, because we knew that she was actually abused. For her, it was a greatest trauma that she could undergo. Was it a reason? Was it because despite all the statutory backing, our courts are still not reminded or aware that there's a victim-centric approach that is required under the statute? So I thought, as I said earlier, like taking coal to Newcastle, I thought I should go along with and remind ourselves what are the provisions where a victim-centric approach has been provided in the statute. One must remember, First of all, what is a victim-centric approach? People have different ideas about what a victim-centric approach is. Some lawyers have told us that PoCSO Act is all favoring the victim. They want every accused to be convicted. Is that actually the victim-centric approach? No, certainly not. Law favors all. There is a right of fair trial. There is a fundamental right to life and liberty which can be deprived only in accordance with procedure established by law under Article 21. So what is a victim-centric approach? United Nations and other bodies have defined that to mean the said approach means to deal with the needs and concerns of the victim and to provide delivery of services with compassion and sensitivity. It's very important. It actually means understand the needs and concerns of the victim and provide delivery of services with compassion and sensitivity. Please imagine the situation. From the time a complaint is filed, a victim has to encounter formidable and daunting challenges from persons who should actually be coming to their aid. The police, the medical personnel, the courts, and even the society. From the registration of the FIR to giving medical evidence and giving evidence in court, the victim is actually undergoing another harrowing experience, and hence there is a need to support. What are the modes in which one can adopt a victim-centric approach? One of the best and the first and foremost mode is instill confidence in that victim. The moment a person, even for a non-abused or unabused person, the moment you have confidence, even for a speaker, you speak with confidence, things just start flowing into your mind. We come across other people, well-dressed, well-groomed, there is an inherent confidence in it. The mental health, all these aspects come into being, and if you're able to instill confidence in that victim, she can come and depose in a manner which is required, which actually depose about the reality that occurred to her. Another method to be adopted is avoid a further trauma. I said there are traumas in taking evidence, during the trial, taking the statement by the magistrates, by the police. Avoid that further trauma or minimize that further trauma as much as possible. Third is treat the victim with respect. She already feels self-blame, lack of credibility. Treat her with respect and she can come back into the society. Ensure confidentiality. Certainly a victim who's been subject to sexual abuse, in the earlier times her name used to be published in the media. Now, that is prohibited by law. It is a measure of ensuring confidentiality of the victim. Provide support to her, family members, judges, lawyers, medical personnel, police, all of them provide that support. Ensure safety for her. And finally, prevent repetition of these offenses. These are the 7 factors which I could identify as a mode to adopt a victim-centric approach. What is the first stage which the law now provides as a victim-centric approach to be adopted? First is victim anonymity in section 23. The media nor any person shall publish the details, parents' details, institution, school, or any other mode in which her identity could be published or could be identified. Second stage is a statement before the police. I've come across few instances where this is grossly violated, either due to ignorance or due to a total lack of sensitivity to what they are doing. And in fact, this is one other aspect that was in my mind when I thought I should go through this, because as the days go by, we, including the judges or the police or the medical personnel, we become automatic to an extent. It becomes monotonous. Day in and day out, we come across these instances. It becomes routine. That monotony creates an insensitivity into us without even us knowing it. So it is a stage where these academic sessions actually reminds us what our duties are. So when a child gives statement before the police, the law under section 24 states that you have to record it at her place of residence or the place of the victim's choice. Why? To give her that confidence, to instill that confidence in her. It must be recorded by a woman police officer as much as possible. That as much as possible, though gives a discretion, we now have, at least in Kerala, large number of police women. The police head of the district must ensure that when a victim of child abuse, child abuse is reported, a woman police officer is recording the version. And a very important thing, police officer must not be in the uniform. Why? Instill that confidence. Even now, I still remember my wife, even now when she sees a police officer in uniform, she runs away. I'm not joking. During the COVID times, when we were walking, we used to walk in our colony. We have policemen inside our house, but still when she saw a police jeep coming in, she ran away. She ran and got back into the house. Why? There is an inherent fear that this khaki uniform creates in us. So imagine a child when he or she sees a policeman in uniform. That is why the statute says in section 24 that the police officer, while recording the statement of the child, shall not be in uniform. The next is recording before the magistrate. I do not know how many magistrates abide by the terms of the statute in section 20, which is provided in section 25 and 26 as requirements and additional requirements. Record it as spoken to by the child. It must be in the child's own words, not the magistrate's words. Presence of advocate to be avoided. It should be recorded in the presence of, it is not police, it is in the presence of parents or a person whom the child can trust if the parents are not available. And use audio video means to record. I don't think it is being done, because Ms. Shantini would be able to speak about that more, whether the audio video means are being used. The fourth stage is medical examination. Medical examination must be in the presence of a parent or a close relative or a person whom the child can trust and have confidence. It must be conducted by a woman doctor if the victim is a girl. Yesterday I was told that it requires some changes, some amendment, because it may not be possible in all circumstances to have a woman doctor attending to the girl. Anyway, all what the statute does is create or instill that confidence in the child victim to come out and speak out. And this is very important. Must be conducted in tune with section 164A of the CRPC. I've come across few cases where a child was subjected to vaginal examination, even though there was no allegation of penovaginal penetration. I was shocked. A child of 11 years being subjected to vaginal examination when there was no allegation at all of penetration, of any sort of penetration. 164A says, in cases where rape is alleged or penetrative sexual assault is alleged, only then you need to conduct a medical examination. In the absence of that, why subject that victim to a medical examination which actually goes contrary to the scheme of the act, which is victim-centric approach? So here, the police officer taking the child for a medical examination must be aware about the nature of allegations also. Of course, one contrary thought on that is, the child is not coming out with the truth. and is suppressing an actual penetrative sexual assault, maybe because of a close relative or other person, and has conveyed only an instance of a normal sexual assault without any penetration of any nature. But is it not necessary for a doctor or a police to identify that? That is a food for thought, which may have to be discussed at a later point of time. The next is examination in court. This is a very controversial area, especially for lawyers. As lawyers, I could not digest being compelled to put or ask questions to the judicial officer, put questions to the judicial officer, who in turn puts it to the victim. You may have all undergone this communication class on Chinese whisper. You convey a question to another person, a statement to another person. The moment it is conveyed to the other person, the meaning is lost. That is happening now, according to the lawyers. But the purport and intent of that provision is that the child should not be, the victim should not be subjected to the grueling cross-examination, and the cross-examination that can at times turn nasty. I still remember one of the lady officer who had made an allegation of rape. She came out of the witness box and said that practically I was disrobed in that cross-examination. That is what she said. This is the effect of cross-examination. This can be the effect of cross-examination. Well, you can call it a smart lawyer or a brilliant lawyer, but the victim comes out and says that I was disrobed practically. Now, the legislature has, in its wisdom, and with the experience it has collected, thought it fit not to allow such a thing, and that is why these statements to be put to the victim through the judicial officer. Frequent breaks to be given to the child. I do not know whether this is being followed by the courts. Child-friendly atmosphere to be provided. Presence of the guardian or a relative or a friend on whom the child has confidence. Not to be repeatedly called to testify. These are all the control which the judicial officer has. He is not a mute spectator in the judicial procedure. Even in a normal procedure, he is not expected to be a judicial mute spectator. He is actually the umpire controlling the whole court proceedings. He decides what should be done. So here, when a child is repeatedly called to testify or being subjected to aggressive questioning, which is the next one, the judicial officer can prevent it. Why? Because we need to instill confidence in the victim. We need to maintain the dignity of the child. And that is why the statute itself, in literal terms, provide that avoid aggressive questioning. And the most important, section 36, child shall not be exposed to the accused. I've been told by a few of my lawyer friends some time back, I do not know what the situation is now. Earlier, there used to be torn curtains in PoCSO courts, where the accused and the victim could see each other. That is not the intent. Even when the police officer takes the child to the magistrate under section 164, taking the statement under 164, the accused or the victim should not see each other, even if the accused is arrested. They should never under any circumstances see each other, because it is traumatizing for the child to see her abuser being taken along with her, or in a nearby, or in the same police station, or in the magistrate's office, chamber. So all this is created so that the child is confident. Utilizing single visibility mirrors. I do not know, I don't think it is there in Kerala. Curtains or video conferencing. The child can be examined through video conferencing to avoid the child seeing the abuser. The next one is very important, the evidence. I'm sorry. Evidence of the child has to be recorded within 30 days of taking cognizance by the court. May not be practically possible. Last week I had to handle an issue where a child of 12 years, she's now 16, she was abused for 4 years repeatedly. repeatedly by her own servant. Now, he has been in jail for the last 1 year. I was called upon to give bail. I rejected it 3 times earlier. I was called upon to bail, but the kind of narration in her statement, I could not digest the fact that he will have to be released on bail. But there was no possibility of conducting a trial in the immediate future. This provision, when it came to my notice, I realized that a speedy trial has to be conducted. However, priority has to be given to earlier cases also. But taking note of the fact that the accused is going to remain in jail, I am not inclined to allow grant bail, directed the trial to be expedited. But this factor, the evidence of the child to be recorded within 30 days of taking cognizance, is a significant step in a victim-centric approach. Now, the next one is presumption of commission of offenses, which Raja has already elaborated deep into it. Penetrative sexual assault, aggravated penetrative sexual assault, and aggravated sexual assault. In all these cases, presumption arises. It is also a step in victim-centric approach. Next is section 30. Question of sexual intent is this is an important thing. Explanation to section 13 says, question of sexual intent is a question of fact. Yesterday, one of the speakers spoke about the grandfather keeping the child on his lap and indulging in a sexual act, sexually abusing the child. The intent is a question of fact, but here the presumption goes against the accused. Of course, it is a rebuttable presumption. Burden of proof of rebutting that is on the accused. Awareness, media publicity. Now, this is one topic which I have always felt that we are actually short of complying with the requirements of the statute. Section 43 of the statute says that there must be media publicity through TV, radio, print. We have all watched anti-smoking campaigns in the movie theaters. It has had a tremendous impact. Yours truly is also one of the beneficiaries of that TV ad, those theater ads. The statute in section 43 incorporates this, but have we ever come across such an ad? It is a bounded duty upon the state and the central governments to provide for this. Every media, public and private, they have to get a license. Why not incorporate that as a condition for license, that every day devote 1 minute for a sexual awareness campaign? This can have far-reaching effects because it goes deep down into the villages also. The illiterate, all of them watch TV. Even though they can't read and write, they watch television, they watch movies. If a particular time is devoted for this print, social media, or TV, radio, everything, none of the governments have given any concern for this. Age-appropriate education material and curriculum to be prepared. This is one judgment which was mentioned by the compeer that I had delivered. In fact, what we realize is that most of the children, even above 16 or above 14, indulge in this relationship under the assumption that consent is a ground for avoiding the criminal offense. They are unaware that it is not so. What is the reason? The problem is we are the problem. We have never communicated to the children. The provisions of the act has actually not infiltrated into those who are the real victims, the children. They are the ones to be aware that the boy or a girl, both of them, may tend to lose their life. That is why awareness is very important. It has to start from the school curriculum. Now, I had directed that this to be incorporated as part of the school curriculum. Well, CBSE has come up with a draft report. They have agreed to make it part of the curriculum by the next year, 2023-24. That was a direction. Unfortunately, Kerala State is still seeking time. A committee has been formed, but nothing has come on record. It's a case pending, so I'm not speaking much about it. Erin's Law. While working on that particular case, I came across this instance of Erin Merrin. She was a lady in the United States who was subjected to severe sexual abuse. Her books are available online also, in Kindle also. She says that her neighbor started abusing her. Her friend's father, close friend's father, started abusing her repeatedly. She just could not respond. She was so traumatized that each time he comes into the room, she could not react somehow or the other. It took her 4 or 5 years. By the time she was practically destroyed mentally and physically. And then she garnered her courage and she started addressing the Senate of every state, saying that this must be made part of the law. Sexual orientation, sexual awareness of a child's sexual abuse must be made part of the law. And finally, one state passed that law, making it mandatory for every institution to impart training in sexual awareness. Now, 37 states in the United States have accepted it. If India passes this, makes it mandatory as part of the curriculum, we will be the second country in the world to include this. Erin continues to advocate for making it part of the curriculum in every state, every part of the world also. Form A and Form B. I doubt whether this is known to anyone in Kerala. I have not come across in a single case diary about the entitlement of the victim to receive information that she has given, and also the preliminary assessment reports. Now, why this approach? This approach is intended to achieve what the preamble of the statute declares and also what Article 39F of the Indian Constitution requires, of the directive principles of state policy. The state shall direct its policy towards securing state where children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. This is intended to achieve this directive principles of state policy. Now, why this approach is necessary? As I mentioned in the beginning, avoid issues of self-blame and lack of credibility for the victim. Avoid and overcome the mental health issues for the victim. Avoid and overcome social stigmas. In this context, I must mention a person known to me had complained about an abuse. She was a girl of 22 years. She went to a clinic in Cochin. She was sexually abused with her mother sitting next to her. On the first day, she did not realize it was intentional. Second day, it was repeated. She thought it must be, maybe without realizing that it is an abuse. On the third day also, on all 3 occasions, this happened when her mother was there. And mother said, I did not even realize. These predators, the manner and mode in which they commit this act is unimaginable. Those who have not undergone this sexual abuse will never able to realize. And when this girl complained to her parents, they just could not believe, because her mother said, I was sitting there. I did not see. Finally, she took the courage and she went and lambasted that person. So, avoid and overcome social stigma. The parents were scared to convey it to the public or to report it to the police, fearing social stigma. They come from a very reputed family. To convey that the child is not ignored but cared for. This particular child felt she was ignored by her parents when she complained. The parents did not believe what she said. This is reality. I know this. To ensure that the victim develops confidence to depose before court. To ensure that the guilty gets a punishment he deserves. Here, I would say, the intention of creating a victim-centric approach is not to convict the accused in all cases, but only to ensure that the victim has the confidence to speak the reality, the truth. so that the guilty gets punished and does not go scot-free, and to make life meaningful and to carry on life with dignity, which is the cherished objective of right to life and liberty under Article 21. I close with one incident. While we speak about all this, I take you back 3-4 years when I read an article in one of the leading newspaper dailies and also witnessed a former principal of Calicut Medical College being dragged by the police with breaking news, flashing that he is arrested in a PoCSO matter for sexually abusing an 8th standard girl. Unfortunately, the next day also the news was carried in front pages. 2 days later, a very small news on the back of the newspaper said, the said accused has been released as it was a case of false information. The reason being, the counselor in the school said, child abuse or sexual abuse means any stranger who touches your body below the neck and above your knees is an instance of sexual abuse, please report it. The child said, this doctor uncle touched my abdomen yesterday, pressed my abdomen. Immediately complaint was given, police arrested without looking into anything, police arrested. Later in the evening, the parents came to know about it. The mother went to the police and said, I was there with the child, that's a family doctor. She had stomach upset. I took her, I stood with her, and this doctor is a 62-year-old retired principal of a medical college. But imagine the trauma that family has undergone, the devastating effect of that person. Lifelong, for generations to come, people who know them, they are branded with that tag. There's also a factor which we must remind ourselves when we think about victim-centric approach. So instill the confidence in the victim so that she comes out with the truth, so that only the guilty and only the guilty gets punished. Thank you very much. Thank you for the question.
Thank you, my lord, for the valuable suggestions.
Moving on, we will now have the responses from the delegates. May I humbly invite the first delegate, Mr. Satish Kumar V, Judge, PoCSO Court, Perumbavoor, Ernakulam, to offer the response.
Honorable judges of high courts, delegates from various stakeholders, my colleagues from district judiciary, good morning to one and all. From my experience for 2 decades in the judicial service, I can say that the most difficult position in judicial service is to become a special judge in PoCSO court. Every time when the court takes a victim-friendly approach, allegations come from the other side, from the side of the accused, that court is taking the role of a prosecutor and it will affect fair trial. As and when court, we know that court is not a silent spectator. Court, trial is meant for finding out the truth. Whenever court exercises its power to put questions, allegations come that court is siding the accused or court is siding the prosecution. And adding fuel to the fire, there are certain provisions in the Act, like reverse burden. How the reverse burden start, when the reverse burden arises, how the onus shift, how it can be discharged, there are a lot of confusions. Today, in the inimitable style, Honorable Justice Raja Vijayaraghavan has cleared there, and we know how the presumption works, and actually in practice how the presumption works, and what is the significance of the presumption, and it is stated, quoting the word, that presumptions are just bats that will move swiftly in twilight, but vanishes in the sunlight of actual fact. This is all about presumptions. And regarding child-friendly approach, sir, we are using a video conferencing facility, and child is keeping the next room, next to the court room, and child is not being taken to the court, and questions are being put to the child, questions being asked in, there's a special procedure in PoCSO Act that either prosecution or the defense counsel is not allowed to put questions directly to the witness victim, and questions shall be communicated to the judge. Judge will put questions. Here also, some defense counsel challenges it, even though there is a specific provision in section 36 subsection 2 that child can be examined through video conferencing or a single visibility mirror or curtain be used. This procedure is also being challenged in court, stating that they want the victim in the court because they want to terrorize the child by raising their voice, and they are sure that they will get advantage by terrorizing, frightening the child. So this practice of extracting true, letting the child see the child of age group 3, 4, 5. It's very difficult to let the child understand the questions put to them, and more difficult is to extract answers from them. Moreover, there are difficulties being faced by the court. Every case leaves a scar in the mind or a deep wound in the mind of a judge. And I frankly say, after a tenure of 3 years, PoCSO judge needs counseling because mental equilibrium of judge is at stake. And we are fortunate because this colloquium served the purpose under the JJ Act and under the PoCSO Act. We know several inputs given by this colloquium will benefit us. And sir, one more thing. Sir, frequent breaks are being given in PoCSO court, and we are giving water, and we are giving even biscuits, and we are giving even lunch. If the child, we are asking them whether what you had in the morning, are you starving? If they say that they are starving or they want water or they want biscuit, we are providing. Even lunch we are providing, sir. Sir, we are taking a child-friendly approach in letter and spirit. I extend my sincere gratitude.
Sadish. What about the forensic reports? Delay in getting reports,
There is some problems are being faced by the court. That's a delay in getting reports from the FSL. That delays the trial also. In most of the courts, recent 2021 and 2022 cases are pending. In these type of cases, reports are being delayed so that we are not able to start trial. Another difficulty, as mentioned by His Lordship, is that there is a protocol for investigating officers to investigate the PoCSO offenses. Same pattern is used in right from aggravated offenses and minor offense like sexual offense. In all cases, even there is sexual assault or sexual harassment, child is being taken to the doctor, and pervaginal test is being conducted. Then I asked to many police officers, investigating officers, why in a sexual assault case and in a sexual harassment case you are taking this child to the doctor and this examination is being conducted? And their answer is that they want to know whether child is previously subjected to this penetrative sexual assault, or the child is in the incident by this accused. A child was subjected to penetrative sexual assault and child is hiding that fact. So for that reason, so we cannot we cannot rule out we cannot say that such a procedure is wrong, but they have a sufficient explanation for that. Another anomaly is that all cases they are taking the dress and sending to the FSL. FSLs are already burdensome, and this act, without ascertaining whether this will provide some inputs, some connections, some missing links to the evidence of the prosecution, they are sending this MOs to the material objects. Even the offense was reported after 1 year. They are collecting the dress and sending to the FSL. And it also causing, then it should be, should have a ponder over this aspect. Why should, they have to ascertain whether what's the purpose of sending this material object to the lab. If purpose is not served, need not be sent to the lab.
Electronic evidence.
And regarding electronic evidence, see, child is not able to state all the facts in court. Regarding date of occurrence, regarding time, regarding place of occurrence, child may not be, then considering the tender age of the child may not be in a position to state all these details. Then if there is digital evidence or call details or tower locations, etc., it's very easy for the prosecution to supply these kinds of evidence in child sexual abuse cases. And 65B, then it's law is very settled that 65B certificate is mandatory. It's not mode of proof. It's admissible, question of admissibility. And if prosecution fails to produce, in most of the cases, age certificate. In all cases, prosecution produce the certificate downloaded from the server of the department, local self-government, to prove the age of the victim without any certificate. In such cases, law is, Arjun Pandit Rao is settled that court can, at the instance of prosecution, court can summon, even during the trial, the certificate from the person who is in custody of the system. So such a course can be adopted. Product of consumption, POC.
To collect POC and send it for DNA.
Yes.
But is it essential that in all cases, if such aggravated penetrative sexual assault is committed, DNA is essential, or only when the accused comes and says that he has no access and he denies the offense, and when he takes the responsibility of the reverse burden in which he requires the samples to be tested for DNA. Does it require in all cases that DNA is to be done?
Madam, if the victim supports the prosecution case, the charge, it is direct evidence. Then this DNA evidence is only corroborating the evidence of, in all cases, DNA test positive DNA result is not at all required. But in childbirth case, or in abortion, child having been pregnant and abortion conducted, and normally that POC shall be sent to the lab and test being conducted. If that test is negative, as last day's deliberation, we know that it's not a foolproof test. DNA report is not a foolproof test. There is mistake is likely. So if the victim says that such an incident, penetrative sexual assault happened, so there is no reason to disbelieve the victim, and this DNA report can be rejected. It's only corroborative piece, only advisory nature.
No,
it will not have, DNA report will not have any overriding effect over the oral evidence of the victim unless there is, it is impossible to have such an incident. then only oral evidence can be rejected and we can accept the DNA evidence.
It's not a question of accepting or rejecting. I would say in the first instance, whether if at all it's necessary to send the sample for DNA. You can collect the sample and keep it.
Madam, if
Preserve the sample. Because on that score, it's being delayed. See, just be supposing if you just a simple aggravated penetrative sexual assault without the conceivement, all right. We don't require any DNA. Just because the child got conceived.
The practice being followed in Kerala is that
yeah, the practice which I
in all penetrative sexual assault, this vaginal swab and smear will be collected, and blood of the accused also collected. It shall be sent for DNA analysis. That's a practice being followed in Kerala, madam.
All right.
Attempt is to close all the doors for the accused. When it comes up, shut all the doors so that he doesn't have an avenue.
When I was holding a PoCSO judge at Chennai, I made it a practice that DNA, if a child has got conceived and sometimes if she delivers a child and the child becomes 2 years or 3 years, DNA report doesn't come. So I made it a practice that if a child comes and deposes evidence, then there is a presumption and when the fundamental facts are proved, what is the necessity? If at all the accused comes and denies, it's all right.
Accused will deny, definitely. He'll take all contingency. He'll also say that this child is not mine.
And the paternity and access, specifically.
But all precautions.
Madam, we are having 2 more delegates. After that, we will just reserve our questions after hearing them.
Thank you, thank you.
Thank you, sir, for your valuable response. May I now invite the second delegate, Mrs. Priyanka G, IAS, Director, Women and Child Development Department, Government of Kerala, to offer her response.
Honorable judges, delegates from the judiciary, executive and various civil service organizations, a warm good morning to all of you. Today I am here to speak on, give the response on 4 thematic areas. The first thematic area being the institutional, institutional approach that is being followed by Women and Child Development Department. And the second is the pragmatic shift towards non-institutional care approaches. The third being one of the important challenges that we face when it comes to PoCSO survivors. And the fourth is what are the future plans of the department in the coming financial year 2023-2024. After this, maybe we can take question and sessions, and if the time is not permissible, I will be available during the break also, we can speak then. Regarding the first approach, that is the institutional setup when it comes to gender-based violence. The nation woke up to the horrors of gender-based violence way back in December 2012, the infamous Delhi gang rape case. But I would like to highlight one important initiative that the state of Kerala introduced the Nirbhaya policy much before this, that is in March 2012. The state of Kerala has a policy regarding the approach and the institutional mechanism by the policy called Nirbhaya policy, which was established in 2012. So it is implemented by the Women and Child Development Department through a dedicated cell called Nirbhaya cell. Maybe Kerala state is one of the very few states which has a dedicated cell for addressing the gender-based violence. And the emphasis of the policy is towards prevention, protection, prosecution, rehabilitation, and reintegration of sexual abuse survivors. I would like to highlight a few of the institutional homes that we have started in the state of Kerala. We have 22 homes which are being run under the Nirbhaya home, the Women and Children home or the entry homes which are present in almost all the districts. Then we have a home for special need children which is about to be started in Thrissur. It will be operationalized by the next financial year. We have mental health home for the survivors who have mental health issues. And similarly, we have SOS and model homes also. We have aftercare homes. That what about the survivors after they attain the age of 18 years old, to address their skilling, their job placement and aftercare. We have aftercare homes also. And another home which I would like to highlight is the integrated care center. So the importance of this I understood only when I recently attended a national level workshop in Lucknow, wherein many states approached us as what is this integrated care center. So integrated care center is a place wherein the pregnant PoCSO survivors can stay there and undergo abortion if they want. They'll be given all the medical, nutritional and psychosocial support. And if they want to continue the pregnancy, they can continue the pregnancy. They can stay there for 6 months. And after the delivery, they can choose to surrender the child, or they can choose to have the child. So their whatever is their right and interest, that will be protected. Their confidential will be protected. They will be given all the medical, nutritional and psychosocial approach. So many states do not have such an institutional form that what to do with the pregnant PoCSO survivors. So we have such care, and many states wrote to us saying that please share the government orders and what is the formalities, how do they select the NGOs. So we shared our best practices with the other state also. Now the second thematic area that I would like to speak about is the non-institutional care. Because there has been a general shift in the focus all over the world from institutional care to non-institutional care approaches. Even when it comes to the PoCSO survivors, we have introduced number of non-institutional programs. One of the most important one is Kaval Plus. It has been taken by the erstwhile Kaval, which was implemented for child in conflict with law. So we are in tie-up with many NGOs, with the NGOs, one in each district. And the approach of the Kaval is that it takes care psychosocial approach for deinstitutionalization of the child sexual abuse survivors, because not all child sexual abuse survivors are there in our homes. Majority of them are there back in the society also. So what about their trauma? Because the accused lives in the society, but for the survivor to be in the same society, it takes lot of trauma, guilt and all other traumatic issues which will go on for a very long time. So how to handle and support those survivors so that they are able to lead a better life. So what the programs that we are supporting, totally 735 children in the grassroots level. So the focus is to identify vulnerable children and to provide support, identify children at risk from the community and providing holistic care, providing interventions so that we do group counseling, we counsel the parents, we give skill training, we help parents as well as the child get all the government schemes, all the provisions under the various government schemes and various department. We try to do the holistic approach of the CSA survivors who are in the society. Now the second important project that was recently launched by the Honorable Minister is the preliminary assessment. So what usually happens is once the PoCSO is reported, PoCSO case is reported, the child is immediately shifted to one of our homes without properly assessing what was the need of the child. So there is a lot of institutionalization that is happening. So in order to understand, is the institutional really required, or is there any other approach required? So we have trained our school counselors to do a preliminary assessment, to collect data and to ensure what is required from the child to create an ICP, whether institutionalization is required or any other support is required. To do all this preliminary assessment, we have trained our school counselors, and it was launched on January 24th on National Girl Child Day. Then the next program that we have is Ashwasa Nidhi. Ashwasa Nidhi is emergency financial assistance both to women as well as children who face gender-based violence. It came into effect on 2018. So various uh, various activities like sexual assault, gang rape, loss of life, grievous injury due to domestic violence, rescue women and children who are rescued from traffic, uh, victims of acid attack, victims of burns, loss of fetus. All these things are being compensated from 10,000 to 2 lakh rupees. And here the FIR registered is the only document that is required, and we do not wait for the prosecution, but even without the prosecution starting, based on the FIR registered, the emergency financial assistance is given through the Ashwasan Nidhi program. Then we have also started Dhira program, which is training martial arts, training the young girls between the age of 10 to 15 in martial arts. We are selecting who are children who are survivors, whose parents are addicted to alcoholic substances, children from SC, ST and remote areas, children who have lost one or both parents, children who are economically backward, and other vulnerable circumstances. So girl children in the age of 10 to 15 falling in this category are being trained in martial arts in 3 panchayats per district. So these are the non-institutional approaches that we are trying to follow. Now coming to the third thematic area, which is what is the challenges that we are facing. So usually in our department, we deal with 3 kind of children. One is child in need of care and protection, the orphans, surrendered, and children with weak family background. The second is child in conflict with law as per the JJ Act. And third is children who are sexually abused. These are the 3 category of children that we are dealing with on a day-to-day basis. So for the first 2 category, we are also trying deinstitutionalization and alternative family-based care, wherein we do not want to put all the children in the institution, because across the world, from many years, there has been a strong belief that institutionalization will result into many psychosocial adversities, and children can develop into their full potential being in their family or being in the society itself. So we are trying to deinstitutionalization of CNCP and CCL category, wherein we are promoting adoption, foster care, family strengthening, sponsorship, aftercare. So we are conducting various programs for this. But we are not able to do, one of the biggest challenge in Nirbhaya Cell is we are not able to do the same thing to a great extent when it comes to child sexual abuse survivors. Because why? First of all, child sexual abuse survivors come to our institution. They come basically for 3 reasons. One is the accused is the close family member, so they are not able to stay in their home, hence they come to the institution. And second thing, to get legal support, so that they are not swayed by the close relatives who are the accused. And third is that they get psychosocial support and also educational facilities. They come to our institution. So whenever I visit our Nirbhaya homes, many children, they say that they want to go back home. That is all they want. They are given decent facilities in our homes. They are given very good education in very good educational institutions. And many of the support we try to give through government as well as through NGOs. But is the one thing that they really want is to go back home. They say that they want to go back home. And we are not able to send them back to home in most of the cases. So that is this part of deinstitutionalization is becoming a bigger challenge when it comes to child sexual abuse survivors. But on the other hand, when it comes to CNCP, even we are thinking to a level wherein there are so many NGOs who are running institutions. We would want to convert them to a daycare center. We would want them to survive. We want them to be daycare centers. They'll bring the children from vulnerable families, give them the education and the tuition, the cultural support in the cultural activities and everything, and then drop them back to their families in the evening. So we can avoid institution, and the institution can get converted into daycare center. So we are proposing this idea to the government also from my side. But on the other hand, deinstitutionalization of CSA is one of the biggest challenge we are facing. Now coming to the fourth thematic area, that what are we planning for the 2023-2024? So as I suggested earlier, we have started Kawal Plus in all 14 districts. It was started in the 22-23. We would want to strengthen them and make them more perfect in the coming year. And the second thing that we would want to do is train number of stakeholders who are involved in the PoCSO prosecution, be it government pleaders, the police officials, the medical. This one we would want to conduct a training and sensitization program. And the third is for the child sexual abuse survivors, parents. We want to give some skill training and ensure that their family is strengthened. So maybe in some of the cases, the parents will take back their children home. If we strengthen their family through skill building, skill upgradation and placement of the parents, they may take back home. And the fourth one, which just occurred to me right now, it was suggested by the Honorable Judge here. Giving TV advertisement or theatre advertisement is slightly a costly affair, so we generally avoid it, and this year it was restricted only to two themes, that is anti-domestic violence and anti-dowry themes. But sir, next year we would want to take this up and ensure that we give theatre advertisement at least for a limited period of time from our department. We would like to do.
Just had you without interrupting you. I do not know why you say it is costly affair, because if it can be made mandatory by the media people itself to show, it is an obligation, their social obligation. Part of their social obligation to show it. The government can bring in policy measures.
Yes, sir. That also will do the suggestion, sir, because usually it takes around 22 lakhs for 1 week of advertisement.
It has to be done free of, it has to be done free of cost as a part of the conditions of license.
Yes, sir. We'll definitely put up a proposal to the government so that it can take it up at a higher level. And in meanwhile, we will definitely use the funds of the department to do immediately.
My brother was saying as part of CSR.
Yes.
Part of CSR also this can be made mandatory or as a condition of license. It is not an advertisement. It's a social objective. And as a part of conditions of license, they can say it cannot be charged. We will provide you the video, but you have to show it every day 1 minute. 1 minute of your
even 30 seconds is very powerful, strong behavioral change communication modules can be prepared by us, and we can definitely share it, sir. We'll do that. So this is from my side. If any questions I would like to take, any best practices with a limited period of 10 minutes, I could not elaborate on many of the things, but I would be available here during the tea break also. Thank you.
Thank you, madam, for highlighting the steps taken by the government of Kerala. May I now invite the third delegate, Mr. Dharmender Kumar Meena, IPS, Director of Forensic Science, Government of Karnataka, to offer the response.
Honorable judges and dignitaries on dais and off the dais, my response is mainly limited to the effective role of forensic sciences in general and particularly in PoCSO and offences against women and children. I have made a PPT. Please put up the PPT. Is it on? Oh, thank you. Sir, there is a very detailed and beautiful report, Justice V.S. Malimat Committee on Reforms of Criminal Justice System 2003. It very categorically says that application of forensic science to crime investigation must commence from the stage of very first visit by IO to crime scene. And how it should be done, that IO should be accompanied by to the scene of crime by an appropriately trained scientific hand. And sir, if we see the statistics, same committee quotes figures that out of all the cases registered, 5 to 6%, only in 5 to 6% cases, samples are sent to FSL. And this data I compiled for Karnataka till of last 4 years. It put the figure somewhere 14%. In 14%, 15% cases, the samples are sent to forensic science. When we compare it with the Western countries, advanced countries, their percentage is somewhere 35, 39%. It means they use forensic sciences in their criminal investigation in much more detailed manner. In our country, probably the penetration of forensic science in criminal investigation, it is on little lower side. And that too, the role of forensics till now traditionally is limited to lab only. What IO will go to scene of crime, collect evidences as per his training. Mostly policemen, IO assistants are poorly trained. They are not properly trained in management of scene of crime. Whatever evidence is as per their knowledge, they'll collect. They'll pack it as per their knowledge, and then they'll send it to the forensic lab. The role of forensics, mainly traditionally in our country, it is restricted to lab till now. The forensics experts, they will analyze the evidences and they'll submit a report to the court. But in this traditional approach, I feel in 50 to 60% cases, the evidences are lost. Either they will miss it at the scene of crime, or they will poorly pack it. By the time it reaches lab, it will degrade. And in the lab also there is a delay. So it will degrade there further. So, I'll like to draw your attention, in most of the states, the name of directorate which deals with forensic sciences, it is Directorate of Forensic Science Laboratories. It is not named as Directorate of Forensic Science Services. Mainly it is very limited mandate they have given to themselves. So in Karnataka, sir, we have since last two and a half year, we have had a detailed deliberation how to improve it, how to do something which basically change the whole perspective through which we see the forensic science services in the criminal investigation. So we call this approach as a scene of crime to court approach. So in this, right now, as everybody knows, most of the places, the scene of crime is mainly handled by policemen. They will handle it, and they will send the evidences to the lab. But in Karnataka, sir, in first of its kind initiative, we have we have recruited 206 scene of crime officers, sir. So 206 scene of crime officers. These officers are basically graduates or postgraduates in forensic sciences. These officers will be the officers of Directorate of Forensic Laboratories. They won't be the police officer, they won't wear uniform. They will go and handle the scene of crime and assist the IO to basically search and identify evidences, properly pack it, and hand over to IO for further investigation. So this photo, we have already started it. This photo is actually a real scene of crime where the SOCO officers have gone there and they are collecting the evidences. So this is one of the important initiative we have taken, and it has been appreciated by MHA, and they have written to all the states that it should be adopted. Then next is these scene of crime officers, they are basically given a mobile forensic science laboratories. This lab is a full-fledged basically lab where it contains 16 types of kits which deals with biological fluid, firearm cases, and gunshot residue, and DNA, how to collect DNA evidences, all type of cushion document, digital evidences and all. So 16 type of kits are there, and this lab is basically, there's a workstation is also provided, so they can basically use it and properly pack it, label it, and hand it over to IO. And recently in our Karnataka DG and IGP has made it mandatory to use call mobile forensic science laboratory to the scene of crime in the offenses which pertains to offenses against women and this narcotics cases, ITPA cases. So there are certain type of heinous cases where the punishment is more than 6 years. It has been made mandatory to call the mobile forensic science laboratory along with the forensic experts to handle the scene of crime and proceed further. In subsequent time, it will be extended to the entire state, including rural areas, because right now we have only 13 mobile forensic labs, 6 are in city and 7 are at the range headquarters. And one of the very unique initiative which we have taken in Karnataka is we have developed our own software, forensic science forensic laboratory management system, basically to increase confidence and maintain integrity of chain of custody while shifting the articles from scene of crime to police station to lab. So each article will be given a unique QR code. No detail will be written on the article. Usually what is every article, every evidence, everything will be written. Crime number, police station, all the sections of the law. But here what we have done, we have encoded the entire information in a QR code. Only QR code will be there. Nobody will get to know if this article belongs to which case, which police station, so that there are no chances of mischief anywhere. And this software, basically it's a completely paperless. It's all the reports are e-signed and sent electronically. And one of the main feature of this software is that in the lab, the cases are allotted randomly. Nobody decide who will do which case. So that also basically ensure that ensure the integrity of the whole process. There are frequent allegations that cases are managed and all everywhere. In fact, 3 days back only, there's one video on India Today of one of the state in North India where the Deputy Director Regional Forensic Science Lab, he is demanding money or basically asking money for manipulating the FSL. So it is possible only when which reporting officer, which scientific expert is doing which case. Then only it is possible, otherwise it's not possible. So in this software, all these details are masked. Reporting officer knows which case he is doing, or director knows. In between, deputy director, assistant director, they don't know which case they are doing. So, and cases are allotted randomly. They cannot choose which case they will do. So this is another feature, one important feature we have included. And of course, the very close supervision, we can track how many cases are pending with whom since how many days. So it's a quite useful initiative from perspective of supervision of the FSL. And another important this initiative which we have taken is that we have entered into MOU with National Forensic Science University, Gujarat, in the areas of training and research. So both the organizations are collaborating and training our forensic science experts in NFSU Gujarat for the 3 months. So till now we have trained 150 officers there, basic foundation course of 3 months, and it's of course a paid training. So government of Karnataka is kind enough to sanction up to 4 crore rupee for their training, and it is giving us very good result. All the forensic scientists which we are recruiting newly, they are being exposed to the world-class training, because this National Forensic Science University Gujarat is the only forensic science university in entire world. Another very small but very significant intervention government of Karnataka has done is that they have amended 273 CRPC. Why it is useful? Because while attending the courts, to attend one evidence in a court, basically it wastes 2 days of my forensic expert. It basically wastes man hours, which leads to the delay in the basically analysis at the FSL. So now at the Karnataka specific amendment in CRPC, now forensic experts can depose their evidence through video conference, and it will be as good as they are going and attending the court. And another step which we have taken is NABL accreditation of all laboratories to maintain quality and standard of services. All are right now, Directorate of FSL Karnataka is having 8 labs, 1 mother lab at Bangalore and 7 regional labs. Out of that, all our labs are accredited as per the latest NABL standards, and our cyber forensic sections, they are certified by METI as per the
Excuse me,
information
sir.
tech.
Can you?
Oh, okay, ma'am, sorry. So triple E certification is there. So way forward is we want to have one scene of crime officer in each police station and one mobile forensic lab in each district, and more labs for DNA, mobile and audio video forensic. Government of Karnataka has sanctioned 2 more labs in this budget for us. So I just wanted to present it. If it is useful for other other states, they can take a cue out of it. So thank you, sir, and thank you, ma'am. And it was a wonderful opportunity to come here and learn many things. And thanks for wonderful arrangement of stay and transport. Thank you.
Thank you, sir, for highlighting the steps taken in forensic science services in the state of Karnataka. Moving on, now we will have the interactive session with the other delegates.
Because of time constraints, first I will give my concluding remarks, and
Sure.
then we will ask the
Sure.
if there is any interaction from participants. As per the recent survey, 1 in every 2 children is a victim of sexual abuse in India. These statistics, these are very hearing these statistics, we are very aghast about it. 1 in every 2 children means almost 50% of the children are subjected to sexual abuse. This is, and almost every woman must be facing at some time or other of her life some assault or abuse or some unwanted touch or something against her. If this is in public places and everywhere, it's continuing in buses, in public transport, exhibitions, malls, wherever public or in large number also, women is facing such type of assaults and abuses against them. To prevent them and speaking against them itself is a lot of courage, needs a lot of courage for women or children to speak up. Many of them were going unnoticed and going unreported. Because of this PoCSO Act, many of the cases are getting reported now. We have to encourage this reporting and to give the courage to the victims to speak up. Only when they speak up, their stress is reduced. And it is very much important. And today, we were given a very good account of the topics on the evidential burden in child abuse cases by Justice Raja Vijay Raghavan, the judge of High Court of Kerala. And as this PoCSO Act is a deviation from the regular criminal acts, where the presumption of innocence is there in the regular criminal law and mens rea is required to be proved. But in these cases, particularly in PoCSO cases, mens rea is not required to be proved, and there is a presumption of guilt rather than innocence. But even then, we should not lose stock of the nature of these crimes, that the evidential, it's the legal burden is always on the prosecution, but it's only the evidential burden which shifts to the other side. And these offenses shakes the conscience of the court and leave a lot of impact on all the judges who are conducting these cases also. I am also happen to work as a PoCSO court judge, and I know how much impact the listening of these horrifying stories of the victims will leave and haunt us all over our career and all over our life. And in this, the other speaker, Justice Bechu Kurian Thomas, had also given a very good account of what is a victim-centric approach and how a victim-centric approach should be there. The fundamentals of all the necessary facts which has to be proved are given by Justice Raja Vijay Raghavan, and Justice Bechu Kurian Thomas had given us as to how a victim-centric approach should be there and how we can avoid or minimize the trauma by maintaining the anonymity of the victim, allowing support persons, and in awarding compensation and seeking rehabilitation. And the victims and how they will be left with the feeling of guilt, shame, and thinking and having a very low esteem about themselves, and how the child should not be exposed to the accused, and the requirements for the speedy disposals of these cases in recording the evidence within 30 days of taking cognizance, and all these things were given a good account by our speakers. Our speakers of Judge PoCSO Court, Perambur, Satish Kumar, had also given his experiences as a PoCSO Court judge, and the Director, Women and Child Development Department, Government of Kerala, Ms. Priyanka, had also given us about the homes which were available and the care and precautions they were taking in reducing and minimizing the stress on these victims. And the Director, Forensic Science, Government of Karnataka, the IPS officer, Mr. Dharmendra Kumar Meena, had also given us the forensic laboratory needs are taken up by their government. Thus, this every good thing will come to an end. Likewise, this 2-day session is also coming to an end by this, and we are going to have a valedictory session now. And I also personally thank the High Court of Kerala and the Honorable Chief Justice, Justice Manikumar Garu, and his colleague judges, the judges of PoCSO Committee and the JJ Committee, and all the judges of High Court, Madam Anu Sivaraman, and all the other judges, with the collaboration of UNICEF also in conducting this program. And I think that, and I hope that we will carry something forward to our places and to our workplaces to bring some positive change in the nature of our work we are conducting, or in being sensitized towards the victim, and in doing our work. I wish all of you a very good luck in your future assignments. Thank you very much.
Thank you, my lord. Thank you, my lord.
Any questions to any of the speakers?
Ma'am, good morning, sir. I just, what I feel today, the 2 sessions are really fantastic, but what I think that we just need to put little extra time and effort in strengthening the existing systems or the plans which is already there. For example, every district, we have a district child protection units, which we have the mandate is supposed to, under the magistrate, they're supposed to have a convergence meeting ensuring the district heads. If you just put little effort ensuring that heads of each department, if the participates, it will go a long way. The second one, I think in Tamil Nadu we have the Judiciary Academy, we have a research units. How are we using efficiently and effectively the research units? Ever since the last 3 years, the Academy research unit started doing a lot of periodic research. It has also supports the training programs. I think we move away from this training program. It's from activity completed. It should not be activity completed. It's not a training calendar once in a year. There should be a periodic refresher trainings which really required to take this program to the next level, because we have all the mechanisms are there. And finally, sir, I think the state of Kerala, I've been working for the last so many years with the government. I think it's the first in the country where we have started age appropriate school curriculum. you must be aware Ullasa Paravigal. And 2018, even that curriculum also been included as school safety and climate change. When we had a flood, so we brought in some international expertise and education department. 2018, sir. Is there, sir? Ullasa Paravigal. I can share with you this age appropriate curriculum developed by the school department of the Kerala. The second one is, my colleague is here, actually Social Policing Directorate. Kerala Police, in the first time in the country, the kind of 3 flagship programs which they run in the schools, which is called SPC, ORC, Our Responsibility to Children, and HOPE, which is HOPE is dropout children, ensuring back to school. All 3 programs which has been anchored by the police department under the new Social Policing Directorate which is started. In fact, ORC is now fully integrated with WCD. It is not only in Kerala, the SPC and ORC is already been replicated to other states in the country, around 6 states which they have been replicated. And probably in Kerala, this ORC, in fact, the director last time requested the police department, maybe the scaling is a little limited, around 400 schools in the state. We were thinking in this 2023, we wanted to ensure all the schools which will have the ORC program, which will solve that most of the victim-centric approach with the last slide which you said, which will really helpful. Probably I can share with you all the documents to the committee, which we have documented those interventions, and then we will take it forward to the next level. And then getting the reports from the medical fraternity, last 2 years in our state, in fact, the Judicial Academy ensure every training, we are not conducting the programs only with the PoCSO judges as magistrates. We include other fraternity also. Like, for an interim compensation, we'll include the department focal points, and then police, SP level, and also the regional medical officers. So by bringing all of them together as a convergent, I think yesterday Kushi, my friend, she was also saying that, the convergence is only strategy which will work, because child protection, if we are now looking at it as silos, I think if you bring in the multi-sectoral convergence program response system only, it will be able to ensure the best interest of the child. Thank you so much.
Yes, sir. We completely agree with you, sir. Yesterday, Justice, Honorable Justice Ravindra Bhatt, the Supreme Court judge, is also saying that we have to take forward, and every quarterly convergence meets are very much required. Only by these convergence meets and talks, we are talking with all the stakeholders only, we can know the problems which they are facing and how we can overcome them. This, definitely we will move forward and in that manner.
With this, we come to the end of session 4 of the colloquium.
We are slightly running out of time. May I request the Honorable Chief Justice to come to the dais?
Sir.
No, sir, we can end. Yesterday, as part of our deliberations in general, we tentatively proposed a resolution to be passed by this August gathering as part of the Judicial Colloquium's recommendations. After the evening session, the main committee members from the 5 high courts, we sat together and we have drafted a resolution, and it has been now circulated. And with the permission of the Honorable Chief Justice of the Kerala High Court, may I read the resolution. The Regional Judicial Colloquium on PoCSO Act, Juvenile Justice and Drug Abuse among Children, held in Cochin for the 5 southern states of Tamil Nadu, Andhra Pradesh, Telangana, Karnataka and Kerala, and the Union Territory of Puducherry, conducted by the High Court of Kerala on 25th and 26th February 2023, has resolved to strongly recommend to the Union Government and the state governments to take proactive steps to establish the dedicated drug treatment and rehabilitation centers for children as per the guidelines and directives of the Honorable Supreme Court of India, as per the judgment dated 14/12/2016 in writ petition civil number 906 of 2014 in the case Bachpan Bachao Andolan versus Union of India, 2017 1 SEC 653, and the provisions of the scheme, quote, Central Sector Scheme of Assistance for Prevention of Alcoholism and Substances Drug Abuse and for Social Defense Services, effective from 1/4/2018, framed by the Government of India in the Ministry of Social Justice and Empowerment. Further, the Regional Colloquium has also resolved to recommend to the state governments to implement the Navchedana Drug Prevention Module launched by Government of India in all schools for early prevention of drug abuse. Further, the Regional Colloquium has also resolved to recommend to the state governments to conduct awareness and training programs for sensitizations and enhancing the capacities of the members of the juvenile justice boards and the child welfare committees for the due discharge of the statutory obligations and duties as per the Juvenile Justice Care and Protection Act 2015, and also for their intervention in the areas of drug prevention cases. It is also resolved to request the four high courts to ensure that the Registrar General of the respective high court will intimate the above resolution to the competent authority of the Union Government in the Ministry of Social Justice and the respective state government concerned and the Union Territory Puducherry for information and necessary action, dated this the 26th day of February 2023. So with the permission of all, shall we treat it as passed? So we didn't have uniform data from all the 5 states. So in case some states are not lagging behind, we didn't want to give an impression as if some of the states, some of the states which are otherwise doing well are lagging behind. So this is generalized, I suppose. No, yesterday we all sat together and drafted this. So yes, but the general consensus was this. So that's a fine-tuned proposal that you're saying.
No, I do not know how is it in Telangana and Tamil Nadu,
No.
whether these vacancies, CWCs and JJVs are timely filled up? To say.
So if we pass a uniform resolution for all the 5 states and UT, and some of the states are not lagging behind, it may give an impression as if we are not appreciating the good work done by them. So we are entering a little bit of policy arena also. So this generalized, these concerns which are specific should also come within the overall breadth of this generalized resolution that we have passed.
Instead of drug treatment, drug de-addiction treatment.
Drug?
De-addiction treatment.
Okay, which?
6th line.
Para 2?
First para number 1.
Rehabilitation
Steps
centers?
to establish dedicated drug treatment is there. We could include drug de-addiction treatment.
No, Dr. Rajesh Kumar is an expert. He said this generic expression should be fine. That's why this de-addiction I suggested, and he said that this should be fine.
De-addiction would be appropriate. De-addiction would be
Treatment should include de-addiction also, because he is the expert in the field. He also suggested this, and we use this language.
De-addiction would be the better understood.
Treatment is it necessary?
Deliberated on this and finally.
I suggested the same thing. Dr. Rajesh Kumar, who is an all India expert in this, said that this wording should be sufficient.
Moreover, the scheme name is there. The scheme name is there.
Scheme it is there. Scheme it is there. So shall we treat it as passed then?
Sir, one small intervention. Just small, very small. Navchetna people might not be aware. So we can just add Navchetna life skill and drug education for school children. I'll share with you, sir. I'll share with you.
That is in para 2, right? Navchetna drug prevention.
So instead of that, Navchetna life skills and drug education for school children.
So the wording
I'll
is.
share with you. I'll just share with you after this.
Okay, because we have to sign this now.
Okay.
My suggestion is we should incorporate that all state governments shall ensure that infrastructure should be set up to ensure that forensic reports are obtained by the courts within 15 or say 30 days in all states. I don't think in Kerala 2017 matters no forensic reports are there. So we should ensure that we should suggest that.
That was
Setting up labs, infrastructure, personnel.
See, we didn't get into that because some of the states we are not having the data. Kerala, we passed resolutions by the PoCSO and the JJ committee, and we are planning to hold a comprehensive meeting again and pass it. Unless we have a uniform, problem in all the 5 states, passing a resolution of this nature for a regional colloquium for all the southern states. So, we are into that. We will be, the PoCSO and the JJ committee will be calling a meeting of the Home Secretary, probably the State Police Chief and the Director of the Forensic Science Laboratory. Whatever is required to be done in Kerala, we would be doing it without much delay, maybe well within the next 2-3 weeks. So other states, probably, we have a problem here, but we don't want to make it appear as if this is a uniform problem all over southern India, unless we have the facts and figures available. We know in Kerala it is an issue, and Mr. Yeah. What is the wording that should be for the now chair?
State government.
Can you come forward and so that I can?
Sure, sir.
Because this wording was given by you only. Sir.
Yeah, no. I further deliberated.
Registrar General, can we have it corrected? Now Chedana?
After that, state governments, where the state government is written.
State government should implement the Navchedana.
Life skills and drug education.
Life skills
and drug education for school children modules. That's it.
Drug
education.
education
For school children modules.
For school children
Modules.
Modules launched by Government of India.
Yeah.
So the yesterday's wording was now the drug prevention module.
So instead of the scientific is this.
This is the full name.
Yeah. This is the full name.
Okay.
Thank you, sir.
So with the permission of the Honorable Chief Justice and all the members of the August Assembly, we are treating it as passed, and with a small correction, this will be signed by the 2 chairpersons of the committee in Kerala, this is Tali and myself, and we are issuing it as a press release through the Registrar General to be given to the press. Plus, we would request all the participants to take back it to the Honorable Chief Justice and the Registrar General will be writing separately to each of the 5 high courts. But if the participants can also take the initiative to ensure that this is taken up and communicated to the union government and the state government concerned, or the state concerned, that will be good to begin with, and let's see what's going to happen. So, thank you all for this, and the photography session will not be the last part, but I think we should have it immediately so that we don't, if we have it just before the lunch, people might miss, they might be in the rush of going back. So, shall we have the photography session right now? The Registrar General says that since the validity session to be addressed online by Honorable Justice C.T. Ravikumar is at 12 noon. So I think he says that we'll have it as scheduled earlier. That's the last thing. So make sure that all of you stand back for the photograph just before the lunch. We need that because 3 or 4 resource persons have already left yesterday. So we want at least the remaining to be here. All who are remaining here today, please stand back for the photograph just before the lunch session. Thank you.
Thank you, sir.
Yeah, please come. Please come. You can come over here. Please come.
Sir, just 2 points, sir, I just want to add, sir. With regard to Honorable Judge, sir was saying modes to adapt to victim-centric approach. I want to add one more thing, sir. To avoid delay at every point of time is also a point that we have to take with regard to victim-centric approach, because every victim has a right to forget. From the time the case is reported till the time the case is dispersed, I think the victim right to forget the trauma is also an important thing, sir. Secondly, with regard to capacity building, sir, I want to say that we, Kerala Police, have introduced a module called Psychological Aid to Children. which is very, very, it has changed the mindset of the, investigating officer, police as such, how to approach children. I suggest that psychological aid to children can be given to police, health, prosecutors, judges, JJB, CWC, for everyone, not only for the victims, but also to treat the adolescent offenders, sexual offenders, sir. Finally, I think this awareness part, sir, there should be guidelines that should be issued to awareness, because many a time I have witnessed awareness classes conducted at the grassroots level. They only go and talk about section 4, 3, 4, 5, 6, what is aggravated penetrative sexual assault, what is penetrative sexual assault, which may not be, relevant for the children, this thing. I think we need to emphasize upon why child sexual abuse is important and what is the impact of child sexual abuse to the common public than targeting on the sections of penetrative, aggravated penetrative, all those stuff, which for the reason that most of the accused are known perpetrators. So once when the children come to know that this is the offense that can be made punishable, then children may not disclose the offense. It may go counterproductive. On the other side, once when we create awareness, there is a tendency for more cases to be registered, which every stakeholder is actually slightly reluctant to say. Finally, one small point, I think when it comes to PoCSO, we always think about the physical abuse. There's this growing concern, online child sexual abuse. I think we as a stakeholder should wake up before much harm is given to the children, sir. Thank you, sir.
Tea and coffee break now. Please be back here 1 minute before 12 noon. We have an online session, online address by See, it's a valedictory session. Justice Chali, Justice Arun, Justice Anu, Justice Babu, then Chief is Justice Hemalakshma, Justice Ramakrishna Prasad, Justice Surepalli Nanda, and Justice Sundar Mohan. Before. All the committee members and
Welcome back, everybody. The end of his story is a new beginning for many great things. We are towards the close of some long hours of serious deliberations, which have given a sense of impetus to implement the much needed steps towards the goal of achieving a child-friendly justice dispensation system.
May I humbly invite Honorable Mr. Justice Alexander Thomas, Judge, High Court of Kerala, and the Chairman of the committee constituted to regulate and monitor the progress of trials under the PoCSO Act for offering the opening remarks.
Now, let me informally request all the coffee takers to break their coffee and come down. Honorable Justice C.T. Ravikumar is online waiting for us. Please request all the delegates and the participants to be back. So, shall we begin, RG? Honorable Mr. Justice C.T. Ravikumar, Judge, Supreme Court of India, my sister and brother judges from various high courts, Honorable Justice Manikumar, Chief Justice of the Kerala High Court, all the esteemed dignitaries on and off the dais, all the delegates, and all others who have gathered here for today's function. Let me wish all of you a warm good morning to all. Now we have reached the culmination of the 2 days Regional Judicial Colloquium on 3 topics of cardinal importance in the contemporary juvenile justice administration. During the childhood of most of us, we seldom heard about drug abuse among children, deviant criminal behavior by and against children, as well as sexual abuse of children. Though our parliament has passed several enactments, of course, to honor the international covenants and conventions, several decades ago, it is a stark fact that there's a sharp increase in the crime rate relating to the topics which we have discussed and deliberated during this judicial conclave for the last day and a half. That means it is not the absence of suitable legislations, but the shortcomings of the effective enforcement of the laws that may stand in our way in achieving the objectives of the proper administration of these laws. We have a recent incidents of drug mafia using even school children as carriers and sellers. Unless we curb the menace of drug abuse by a younger generation, our enemies may not require nuclear weapons to destroy our nation. On the other hand, by making our younger generations addicts to drugs, they can easily destroy this great nation. The rampant drug abuse would naturally lead to the other 2 menaces, such as offenses by and against children, as well as sexual abuse of children. We have discussed various crucial problems normally encountered in the proper administration of these laws, especially sexual abuse of children, drug abuse among children, and offenses by and against juveniles. These 2 days discussions and deliberations will generate good dividend in future, and we can deal with the enforcement of these laws more effectively and meaningfully. Let us hope. Let me congratulate you, all of you, for your active and wholehearted involvement in this colloquium. Let us, the juvenile justice administrators, be the parents patria of children, not only in our courts and legal system, but also in our thoughts and hearts as well. At the outset, let me profusely thank for all of you for the august presence of Honorable Justice C.T. Ravikumar, Judge Supreme Court of India, for gracing this occasion by his eminent presence. Thank you. Jai Hind.
Thank you, my lord.
We are honored by the virtual presence of the Honorable Mr. Justice C.T. Ravikumar, Judge Supreme Court of India. I am privileged to invite His Lordship to the colloquium for delivering the inaugural address.
Number of cases which I come across carry complaints of sexual exploitation on the promise of marriage. Here I think the women organizations have a role to play. They will have to sensitize, educate them of the evil that spoil their future. Merely because there is a promise from someone that I would marry you, why should the young ladies, the young girls, believe it and simply swallowing that words and go after that person from place to place. And this is a matter I think that not only the parents, the women organization all have to address. Then the responsibility of the state to ensure that all needs of the children are met and their basic human rights are protected, it emanates from the Constitution of India itself. Of course, you know, Article 15, Article 39, E and F, Articles 45 and 47. Time and again, the state has come to the rescue of the system to make it adapt to deal with the changing times of a ever-evolving society. The timelines of any statute would stand as an appropriate example of a legislature's action in the complementary judicial trends shall stand as an example of how statutes are meant to stand the test of time and myriad of challenges. Another horrid statistical fact that the NCRB report of 2021 brought before us was that 58,873 cases were registered under the PoCSO Act in 2021. And 61.9% of them were rape cases. I am compelled to wonder that after 10 years of the working of this statute, an amendment to the statute in 2019, which increased the imprisonment period of several offenses, the cases are still rising, which means our children are at a higher rate of risk. So what's that is going wrong? My humble contemplation have led me to believe that for the legal system to function as a well-oiled machinery, all stakeholders and organs must give their 100%, the optimum. In some situations, it's either the legislation itself that needs a serious relook and reform, and most other situations, it is the implementation that needs a nudge. Children remain vulnerable because of their lack of ability to communicate as well as an adult could do. They need special care and caution, no doubt. Looking at the reason as to why the children are getting involved in criminal activities, and especially you know that in that case, the so-called drug mafia, their influence is a disturbing aspect. And we should ask ourselves why our children are going after them. Is it the lack of sensitivity? Actually, some of them are thinking that we are not secure. The family situations, of course, you know that in some cases, the parents were abroad, and from abroad, they may be sending money. It is not money that matters. It is the sense of security. See, of course, there may be difficulty for a frequent visitation, but at the same time, the parents should be able to send the message that always you are with you, we are very keen, and we are actually following you. If that is not there, see the case of a child who is in a boarding school, and if all his colleagues, all his mates are going on for vacation to their homes, and he is alone, and his parents are not coming back to take him, and then that will create a kind of a frustration in his mind. And sometimes the repeated recurrence of this kind of situations may make him to take to these kinds of activities. Sometimes he may find solace in taking these drugs. So what I'm saying is, we are also responsible for that. We means not only the parents, the society ourselves. Sometimes even their colleagues, they can find a solution. A little bit of advice or taking that schoolmate to their own home, that may make a change. So it is as a whole, we as a society have to address on these issues. Thus, I think that not only the legislations this society has to address this. Don't put the entire blame on the children, and we will have to examine what is going on wrong, why it is wrong, and then correct it. Now that the special legislation but must make sure that every officer, be it on the judicial side or on the executive side or the police, also have adequate knowledge of the working of this law. They can only do justice to the operation of the law once they know the law and its nitty-gritty. It is always refreshing to keep coming back to checking upon our laws and legislations to make sure that they are attuned with the changing scenarios. Seems like in this case, we need to push more on the awareness and education of the already existing laws than any systemic changes per se. Schools should focus on the already existing laws than any systemic changes. And parents could pay special attention to their kids and enhance communication and trust building exercises with their own children. And for this, officers of the legal system, they can develop skills needed in them to do justice to the provisions of an act. And as for us, we must always use the platform that we have to raise our voice for the causes close to our heart and do our bit in whatever form or manner that we can aspire to. I believe in giving credit to where it is due, and these colloquiums, again, this one deserves a whole lot more than just credit. All great initiatives start with just a seed of an idea, and this is a place where it's born. I hope these 2 days of serious deliberations have brought lessons for all of us, and the best way to learn is to learn from each other. I wish all success and carry what you have learned from the colloquium and spread it. Thank you very much. Jai Hind.
Thank you, my Lord, for your precious time and for sharing the thoughts.
Moving on to the reflections and closing remarks, may I kindly request Honorable Mrs. Justice K.S. Hemaleka, Judge, High Court of Karnataka, for sharing the reflections on the event.
Honorable Mr. Justice C.T. Ravi Kumar, Judge, Supreme Court of India. Honorable Chief Justice S. Manikumar, High Court of Kerala. Companion Judges of High Court of Kerala. Honorable Judges of Andhra Pradesh, Telangana, Tamil Nadu, and my state Karnataka, Mrs. Justice Mudgal. And Judicial Officers of all the 5 states. Staff of High Court of Kerala, a very good afternoon to one and all here. It's a task for me. What is there today is, I was a student from yesterday, and I've heard all the teachers speaking here on this PoCSO, juvenile justice, and drug abuse. And my task is to say what I learned from these 2 sessions, what had happened from yesterday. So gist of what happened, I may have to narrate here. That would be my closing remarks. And the thanks to the entire High Court of Kerala for having accorded this hospitality and in the way the entire sessions was conducted. First of its rare kind, wherein 5 states have come together. And apart from this, we have also recommended a proposal to not only to the Union of India, and also to all the state in which we are representing. So that is also one of the big achievement which this regional judicial colloquium has taken through in this 2-day sessions. So let me give a short gist of what happened from yesterday. Yesterday, Justice S. Manikumar Chief Justice, High Court of Kerala, was kind enough to speak of gist of the PoCSO Act, Justice, Juvenile Justice, and the drug abuse. Lordship was very kind in saying that children are the future of our country and we have to build them in a proper way. And then quoting the quotes of Nelson Mandela, and which I think most of our other speakers also have dealt with that. So we have to again forward that the same. And then Justice Ravindra Bhatt, Judge Supreme Court of India, was, I have just note down the points which was done from yesterday. I think as a student, that was the thing which we used to do, but not in the full sense. Now, this was done from yesterday. And then Justice Ravindra Bhatt, Judge Supreme Court of India, was emphasized on the cases wherein the PoCSO Act has been misused, wherein there is a romantic cases, and we are not, we as judges, we involve ourselves in those cases and literally go away with the actual abuse cases. So emphasis was on that basis. And then Justice Shalini, Justice Dr. Shalini Valsarkar Joshi was very kind enough and stressed on the intern discipline and the fundamental rights of the justice juvenile and the child in conflict with law. What the child needs is the need of love. Need of love, we have to treat the child as our own child. When a victim or the guilt comes, we should not assume that the child is guilty at the first instance itself. So then that was emphasized by Dr. Shalini. And then Dr. Shalini also mentioned that the entire, for bringing up a child, the entire village goes around. So we have to, behind every child, there is a list of adults who are responsible for their good being or their wrong being. Somewhere as an adult, we are also responsible for the upbringing of the child. As a woman, when we leave a child and thinking of a woman empowerment, we go out of the house, but behind our mind, there is always something lingering in our head that what is our child doing or what is it going wrong. For men, maybe it is not so because they have got their wife at home. But again, somewhere in the corner of the heart, it is always lingering in our mind that somebody should be there to be taken care. But we definitely give the values to our child as to what has to be done and what not has to be done. But the society, the teachers, and the entire society is responsible for the upbringing of the child as well. So let us all take the responsibility of developing the child in a true sense. And then Dr. Rajesh Kumar was very emphasized upon the green part and the red part area which was to be used. The child, we have to think in a positive manner and not emphasize more on the negative part. So thank you, Mr. Rajesh Kumar, for such an incentives provided by you. Then Khushi Kushalappa was also very kind in saying the same words which Dr. Shalini had proposed, saying that we need to take utmost care of a child when she comes before the court, and treat her in a very nice manner and ask questions so that she is not embarrassed at the first instance itself. And then Bharti Ali also was very a good speaker, and then she insisted that the court should not insist that there should be a child's presence every time. That was very kind. This was the 2 sessions which we were dealing with in the yesterday. First session was insofar as the dealing with the child in guilt, and the second session was regarding the victim. Totally 2 contradictions. But then we came together and we tried to solve a problem by recommending what Rajesh Kumar had suggested to us. So that session went on very well. And then we had Shanta Kumar, who took Dr. Shanta Kumar for sending forensic report medical officer. He was so lively that after such a good lunch which was organized by the High Court of Kerala, we could manage ourselves to get together till 5:30, and that kept the environment quite pleasant. And all the speakers, the entire session was very good. And today, the two speakers, we have no words to speak about them, Justice Vijay Raghavan and Bechu Joseph. So that was very nice of you all to make this session a very pleasant. Thank you everyone. Thank you, High Court of Kerala, for everything.
Thank you, my lord.
May I kindly invite Honorable Mr. Justice G. Ramakrishna Prasad, Judge, High Court of Andhra Pradesh, for closing remarks on the event.
Justice Ravi Kumar, Honorable Judge, Supreme Court of India, Justice Mani Kumar, Honorable the Chief Justice of the High Court of Kerala, my sister judges, brother judges on the dais, off the dais, learned judicial officers, the other executive, who are all dedicated and involved in the implementation of the PoCSO Act and the Juvenile Justice Act. Good morning to you all. Now, my sister Justice Hemleka has taken us through the entire spectrum of the 2 days proceeding. Anything said would only be a repetition of this. I would only just make a reference to Section 43 of the PoCSO Act. Justice Bechu Kurian Thomas has just made a reference also. This is with regard to the preventive part, where the statute requires wide publicity as regards the preventive aspects, which is very, very fundamental, very important part in the PoCSO Act. If the prevention is implemented effectively, perhaps the incidence of offenses under PoCSO would also get reduced. Now, as regards the Juvenile Justice Committee of the Andhra Pradesh High Court is concerned, we have invoked Section 43 to direct the Ministry of Information and Broadcasting to make certain animated videos. This is for educating the young children amongst schools, colleges, and then depending on the various age groups, different kinds of approaches are the ones that we have taken up. As regards the younger children, we have made posters as well as animated films. And we have given directions to the Education Department, the Social Welfare Department, and the Tribal Welfare Department, that these shall be the posters which indicates the 3 important regions, the mouth region, the chest region, as well as the groin region, where what is a good touch and what is a bad touch. And when the parent does it, it's not a bad touch. And when someone else does it, it would tantamount to a good touch. So then what happens when a child understands this in this process? Next step is to raise an alarm, or to immediately go and inform the parents or anybody who's close, or anybody with whom the child can share the feelings that this is the kind of experience that she or he had gone through. So raising an alarm, screaming, and these are the things which actually make the child to run away from the possibility of a bad incident. And therefore, then coming to the animated videos also, we have directed the Information Ministry to telecast, to make it mandatory for all the private and the state channels to telecast. And videos have been just made. In fact, I can even share the videos. Most of them are basically not in particular any language. It is basically silent, but you can also dub any local languages as well. So we can in fact share these videos with our other high courts also, so that they can also give directions to the Information and Broadcasting local ministries to do this. Now, there's one more aspect which I wish to highlight, is to post these complaint boxes in all the residential as well as the day schools, where and it is kept under lock and key. The children can just drop in whatever complaints that they would feel like. It will be anonymous.
and these will be opened only by a committee of responsible members. In fact, very good results have come out of this. We've got very good feedback that the education officers, the social welfare department, as well as the tribal welfare department, they have got back to us saying that not only with regard to the sexual offenses or any advances made by the perpetrators, but they've also been getting feedback about bad teaching, bad facilities in the hostel, and this incidentally has even benefited the officers in getting feedback. So these are the few things which I thought I would share so that will be useful for all of us. I thank the organizers, the Honorable High Court of Kerala, Honorable Judges, for having organized such a fruitful, in fact, having come here, we all have been enriched with greater knowledge, greater information, methods of implementation. Thank you very much. Jai Hind.
Thank you, my lord. Thank you for the good words and your presence.
May I now humbly invite Honorable Mrs. Justice Surepalli Nanda, Judge, High Court of Telangana, to propose the closing remarks on the colloquium.
Honorable Justice C.T. Ravikumar Garu, Honorable Judge, Supreme Court of India, Honorable Chief Justice, High Court of Kerala, Honorable Justice S. Manikumar Garu, all the learned judges on the dais and all the learned judges of the dais and every member assembled here. I believe it's a divine blessing of God Almighty to be a part of this momentous regional judicial colloquium organized by the High Court of Kerala, and I have been assigned the duty of offering the concluding remarks. I would commence my remarks by referring to the quote of the American author and talk show host Oprah Winfrey, who said, and I quote, "Every time a child is saved from the dark side of life, every time one of us makes the effort to make a difference in a child's life, we add light and healing to our own lives." This two-day judicial colloquium, which had been initiated by the High Court of Kerala with an objective not only to regulate and monitor the progress of PoCSO Act, but also to deliberate, discuss about the loopholes in the Act, and to make certain significant recommendations by passing resolutions, and to ensure the implementation of the PoCSO Act in its true spirit, commenced yesterday morning with the inaugural session in the august presence of Chief Justice of Kerala High Court being inaugurated by in the august presence of Chief Justice of Kerala High Court, Honorable Justice S. Manikumar Garu, who delivered the presidential address. The Honorable Chief Justice, not only through his address, emphasized on the need of the benefit of legislation of the PoCSO Act to be achieved to the maximum, but also quoted the words of Nelson Mandela and said that there can be no keener revelation of a society's soul than the way in which it treats its children. Honorable Chief Justice explained and emphasized on the imminent need to ensure a safe future of children and make them good human beings with a mission in life, since our children and are our greatest treasure. They are our future. Those who abuse them tear at the fabric of our society and weaken our nation. The presidential address was followed by the inaugural address by Honorable Judge Supreme Court Sri S. Ravindra Bhatt, who observed that PoCSO Act is a landmark legislation and indicated that sincere efforts should be made to ensure its implementation in its true spirit by renewing our commitment for cause of children. His Lordship also pointed out the lacuna in the Act, as I understood, that the Act does not provide any clarity on what happens when two minors engage in any kind of sexual activity. Technically, they are both children in need of care and protection and children in conflict with law. In practice, though, however, the police declare boys to be children in conflict with law and the girls as children in need of care and protection. The inaugural session concluded by vote of thanks being delivered by Honorable Mrs. Justice Anu Sivaraman, Judge, High Court of Kerala. The first session had Honorable Mrs. Justice K.S. Mudagal, Judge, High Court of Kerala, as its moderator, and two speakers on theme 1, that is child in conflict with law, adhering to rights-based approach and balancing the rehabilitative goals of the Juvenile Justice Care and Protection Act 2015. It was an extraordinary and beautiful presentation made by Dr. Shalini Joshi, former Judge, High Court of Bombay. In her presentation, Madam explained the basic concept of parens patriae by pointing out clearly that the underlying philosophy is that if a child has gone astray, it is the parents who had failed. And hence, at that stage, the state should step in and take over the role of the parent, diagnose the problem, and prescribe the appropriate treatment. It does not matter what the child had done. Her presentation dealt with primarily the objects of JJ system, key features of the Act, stating that the same is a comprehensive legislation which is child-centered, child-friendly, and a complete code in itself to cater to the best interest of the child for dealing with both the juveniles in conflict with law and juvenile in need of care and protection. Madam also referred to the constitutional provisions relating to children, Article 15.3, Article 23, Article 24, Article 39E, Article 39F, Article 45, and Article 4, and observed that they are the basic foundations of juvenile justice. The presentation also included and referred to the objects and reasons of JJ Act 2015, fundamental principles of juvenile justice, salient features of the Act, and the separate forums, that is Juvenile Justice Board pertaining to children in conflict with law and child welfare committees dealing with children in need of care and protection, and separate police unit for child-friendly police personnel for handling children in conflict with the law. The scheme of the Act was explained through a PowerPoint presentation emphasizing on 3 R's. The object of the Act was explained as to adopt child-friendly approach to protect best interest of the child, and the 3 R's, namely reformation, rehabilitation, and reintegration of the child. If further, it was suggested that if in inquiry it is found that the child is actually in need of care and protection, then the child should be transferred to CWC, and the presentation concluded with the words, "Children are small, hence they require big rights." Dr. Rajesh Kumar, the second speaker in session 1, made a PowerPoint presentation on children and drug abuse in India and emphasized on the need to provide de-addiction centers with support of the state governments and to adopt international standards of drug use prevention by adopting life skill programs, family skill programs, by having interactive approach and extending support to families with problems, and by early screening of children at risk. As way forward, it was suggested by Dr. Rajesh Kumar that school-based intervention should be there, community-based outreach, community peer-led intervention, sports for development, and intervention with families. The second session had Honorable Justice D. Ramesh, Honorable Judge, High Court of Andhra Pradesh, as its moderator, and the theme 2 that was discussed was furthering a victim-centric justice delivery system for PoCSO cases. As Speaker 1 and 2, we had Ms. Kushalappa and Mrs. Bharati Ali, and the topics discussed were the basics of child psychology, about investigation and trial, about current practices, challenges and gaps, solutions and good practices. challenges in investigating sexual offenses, lack of witnesses, sensitive nature of the cases, and the main emphasis, however, was on the investigating authority and the family to be connected to communicate information, evidences to be recorded at the earliest point of time, Form A to be given to the family, medical opinion to be based on guidelines, efforts to assure consistency in victim statement during investigation and trial, development of support system, district level quarterly convergence meetings to be held at least twice a year, to ensure that the child and accused should not come close to each other and focus on child's vocabulary and expression since the same needs attention, and orders under 357A, whether granting interim compensation or rejecting the same, should be a reasoned order. Focus was to shift primarily, rather from pendency, to reasons for the delay, and the CWC, the Legal Services Authority, and the Health Development to coordinate and function together for effective implementation of the provisions of the PoCSO Act. And also it was suggested that the Tamil Nadu method, that is to have entire data formatted and above all restorative care to become part of the justice delivery system. Session 3 had Honorable Mrs. Justice R.N. Manjula, Honorable Judge Madras High Court as its moderator, and the theme 3 pertained to effective use of forensic science in child sexual abuse case. The two speakers are Captain Dr. B. Santakumar and Mrs. Shreya Rastogi. Captain Dr. B. Santakumar emphasized on the role of doctors, medical legal consultants, and said that they should be victim-centric and work in the best interest of the child. The child should be protected at every stage of judicial process. The ground reality that the medical examination is not treated as an emergency, but the same should in fact be treated as a medico-legal emergency. The child-friendly procedures to be adopted and the need of the hour for the child victim was explained as uniformity in the medical examination, improvement of basic facilities, sensitization and training of doctors, medical officers to be made accountable, periodic interaction and evaluation with law officers, prosecutors and judicial officers should be undertaken, motivation, dedication, discipline of all officers to be ensured, and stipulated pro forma pertaining to medical examination to be adopted throughout the country. As Speaker 2 of the third session, Mrs. Shreya Rastogi addressed on the point of promoting the use of scientifically valid and reliable forensic evidence with the legal system and dealt with loss of crucial biological evidence due to delayed reporting, regradation and contamination of biological evidence due to delay, and the myths about medical examination in sexual offenses. The session 4 had Honorable Justice G. Radharani as a moderator, and it dealt with theme 4, that is restructuring justice delivery process relating to children in conflict with law and offenses under the PoCSO Act, and it had two speakers, Honorable Mr. Justice Raja Vijay Raghavan as its first speaker, who explained evidential burden in child abuse cases, who referred to Section 29, Section 30, Section 359 of the Act, and explained at what stage Section 29 and Section 30 would apply. His Lordship also referred to the judgment of the Apex Court reported in State of Maharashtra versus Vasudev Ramchandra Kaidalwar, reported in 1981 SCC Volume 3, 199, and explained that in a criminal trial, the legal burden lies upon the prosecution alone. His Lordship also explained the factors that would form the required foundational facts, and also the issue of negative presumptions by referring to the judgment of the Apex Court reported in 2004, Volume 11 SCC, page 576 in A.S. Krishna versus State of Madras. The effect of Section 29 of the Act was explained by placing reliance on more than 10 judgments. And then the second speaker, Honorable Mr. Justice Kurian Thomas, Judge, High Court of Kerala, explained and addressed on the necessity of a victim-centric approach in PoCSO to deal with the needs and concerns of victim and to provide delivery of services with compassion and sensitivity. Modes to adopt a victim-centric approach, as explained by His Lordship, include modes to instill confidence, avoid further trauma, treat the victim with respect, ensure confidentiality, provide support, ensure safety, and prevent repetition of offense. His Lordship also explained the stages at which victim-centric approach is to be adopted by referring to complaint or information, Section 23, and Section 24, the statement of the child before the police, and Section 25 and 26, the recording before the magistrate, and the medical examination as dealt under Section 27. Also, His Lordship observed that awareness on sexual abuse was the need of the hour, and the TV, the radio, the print, and the newspapers should undertake this duty and should follow Section 43 of the Act, so that the duty as cast upon the state and central government is ensured and not neglected. As having responses from delegates, we had Mr. Satish Kumar, Mrs. Priyanka, and Mr. Dharmendra Kumar, and the concluding remarks were delivered by Honorable Justice Radharani, Judge, High Court of Telangana. I conclude my remarks by thanking the organizers for providing me an opportunity for offering the concluding remarks. Thank you, one and all.
Thank you, my lord, for the detailed closing remarks.
May I take the privilege to invite Honorable Mr. Justice Sundar Mohan, Judge, Madras High Court, to share with us the reflections on the colloquium.
Honorable Justice C.T. Ravi Kumar, Judge Supreme Court of India, Honorable Justice Mani Kumar, Chief Justice of Kerala, my brother and sister judges on and off the dais. I first of all thank Kerala High Court for giving me this opportunity to be here and also share my thoughts. I understand I am the last speaker, therefore it is all the more reason for me to adhere to the first principle in any speech to keep it short. I'll adhere to that. There were very informative sessions that we had whole of yesterday and this morning. And we had some experts like Dr. Rajesh tell us that when children use drugs, we should not say abuse. We should only employ the term use of drugs. And that was very interesting. We had Justice Shalini have a different approach while appreciating Juvenile Justice Act. She said, although it's a welfare legislation, we must take it as a right-based legislation. We should not, this legislation flows out of rights of children. So a right-based approach rather than a welfare-based approach should be adopted while appreciating JJ Act. That was very, very interesting. And she also suggested another interesting aspect, that when an assessment is made by the Juvenile Justice Board under Sections 15 of the Justice Act to try an offender, a juvenile offender as an adult, it is based on some medical reports. So the child must be given an opportunity to cross-examine the author of the report, so that there is one more stage where the principles of natural justice is followed. That was another interesting approach. And what Dr. Shantakumar said was alarming. He said many of the doctors, registered medical practitioners, were ill-equipped both in the Mofussil as well as in the cities. That is, see, our conclusions are based on these reports. Once the premise is wrong, the conclusion obviously has to be wrong. Therefore, we have to be very, very careful on that aspect, and I think we should also consider recommending to the government to advise these doctors or give training to these doctors wherever, because lack of knowledge as regards PoCSO Act as well as the way these tests have to be taken, because once their conclusion is bad and our conclusion as judges are likely to be bad. Therefore, that is very, very important. So that is one thing that we should take note of. Dr. Shreya Rastogi gave another interesting point of view. The presence and absence of DNA alone does not necessarily, we cannot infer the presence of the accused or implicate or exculpate the accused. That is a very interesting observation. Many of us think that once DNA is there, the presence is established. That was another interesting observation she made. And we had some speakers on victim-centric approach. Justice Bechu Thomas put it very beautifully, that victim-centric approach by itself does not necessarily mean that convictions can be made in all cases. The provisions relating to this victim-centric approach are all aimed at giving a kind of a comfort zone to the victims. They should feel safe and comfortable during investigation and trial. It does not necessarily mean that the normal rules of appreciation of evidence has to be given a go by. That is, and in fact, Justice Raja also put it very beautifully, that we have to strike a balance between these two, where presumptions, provisions are there relating to provisions. See, my own humble view is, there cannot be any statute which takes away this fundamental rule of criminal jurisprudence of presumption of innocence in an accused. It is not as if our forefathers were unwise. They did not think of the victim. They were also aware of all that, and this is a established principle. I am told it traces back to the 12th century Roman law. Therefore, the principle is presumption of innocence, and even if you find let off 100 guilty men, you shall not punish one innocent person. That is very, very important, because we should go to the why of it. The reason is very simple. The havoc that wrong acquittal can give is less than what a wrong conviction can do to the society. If an innocent person is found guilty, then it hardens that person first of all. Then the society loses confidence and trust in the system. And third and most important is, you are doing injustice to the victim, herself or himself. If you convict a wrong person, you are doing injustice to the victim himself or herself. Therefore, these are some of the fundamental principles on which they said you have to be very, very careful while convicting a person. All right. Now, some of the provisions are very vague. This is where the challenge comes to the court. Some of the provisions are very vague. Unfortunately, we didn't have a Lord Macaulay drafting PoCSO Act. We can see how beautifully penal code is drafted. See, there are at least 3 provisions. We say the resultant act is death, but the punishments are all different. For example, in a 304A case, the resultant act is death. You have the punishment only for 2 years. In culpable homicide, we have no minimum imprisonment. It can go up to 10 years and life in some cases. In murder, it is life or death. So, where the resultant act is the same, they could have simply said, A causes the death of B, yes, life sentence. They didn't put it that way. They took so much pain to define where the culpable mental state is less, where it is rashness or negligence is 2 years, where it is probable that is likely to cause death, it is only culpable homicide not amounting to murder, where it is in all probability likely to cause death, it is 300, and even if it comes within all probability, if it falls within the exceptions, it goes back to culpable homicide. So all this effort was not there, in my humble view, so far as drafting of these legislations are concerned. Therefore, the challenge is more. Now, I would like to also add to what Mr. Satish said, that when you are hearing a PoCSO case, it is definitely a traumatic experience for the judge himself. So this is what I like to quote what Lord Atkin had to tell Lord Denning when he assumed office in 1944. In a letter addressed to Lord Denning, this is what he had to say, quote, "I sometimes say to a new judge, don't forget that the most important and often the most difficult part of the work of a judge is the criminal work." Now, this is, now we have this kind of act where you have presumptions. On the one hand, we have these fundamental rules of criminal jurisprudence, we have presumptions, then we have victim-centric approach. Therefore, the challenge is more for judges. Therefore, as judges, we have to use our training to strike a balance between all these approaches. Now, the other, last and not the least, is the Romeo-Juliet cases. Now, all of us are concerned about these cases where it is not necessarily sexual abuse, it is out of acts committed out of biological needs. At that age, it is biological and it is consensual. But unfortunately, you see the Act does not provide for a minimum, it provides only for a minimum sentence of imprisonment. This is another challenge that all judges should ponder about. And you see penal code offences, not in very few cases will have minimum sentence prescribed. So unless there is a discretion given to the judges in terms of imprisonment, there is a disaster likely to follow, because penetrative sexual assault is a minimum of 10 years imprisonment, and an 18-year-old boy can be convicted for and sentenced to 10 years. And this minimum sentence is something that we must all, because now the government has said we are not going to reduce the age of consent. When that is so, the judges at least must have the discretion to give a lesser sentence of imprisonment, though you don't have an option to acquit the accused in such cases. So that is the thing that I wanted to share with you. Thank you so much for this opportunity. Good day.
Thank you, my lord, for sharing the observations.
As we come to the close of the valedictory function, with great respect, may I invite Honorable Mr. Justice K. Babu, Judge, High Court of Kerala, and Honorable Member, Committee constituted to regulate and monitor progress of trials under the PoCSO Act, to propose the vote of thanks.
Honorable Mr. Justice C.T. Ravikumar, Judge, Supreme Court of India, our beloved Chief Justice, Honorable Mr. Justice S. Manikumar, the other distinguished dignitaries on and off the dais. I stand before you with a deep sense of honor, privilege and humility to express on behalf of the Honorable the Chief Justice of the High Court of Kerala and my brother and sister judges, our profound gratitude to all who have been instrumental to the success of this venture. Veterans in the field made their presentations. Robust discussions were held on the presentations. We hope that the colloquium now concluded led to increased awareness and understanding of the relevant laws, their role in justice delivery system, and the ways in which they could be used to protect the rights of the children and the accused. On behalf of Honorable the Chief Justice and my colleagues, I express our profound gratitude to Honorable Mr. Justice C.T. Ravikumar, Judge, Supreme Court of India, who inaugurated this valedictory function. Our beloved Chief Justice has been guiding us throughout for making this venture a success. Sir, I express on behalf of the committee constituted to regulate and monitor the progress of the cases under the PoCSO Act and the Juvenile Justice Committee, I express my heartfelt thanks to you, sir. I am deeply thankful to the learned speakers, Justice Raja Vijayaraghavan, Justice Bechu Kurian Thomas, Justice Shalini Joshi, Justice K.S. Mudgal, Dr. Rajesh Kumar, Ms. Kushi Kushalapa, Mrs. Bhati Ali, Justice D. Ramesh, Justice R.L. Manjula, Captain Dr. B. Shantakumar, Mrs. Shreya Rastogi, Justice Radharani, Mr. Satish Kumar, Judge, Special Court PoCSO cases, Perimbaur, Ms. Priyanka IAS, Mr. Dharmendra Kumar IPS for their contribution. We, the members of the committee, constituted, regulate and monitor the progress of the trials under the PoCSO Act, and the Juvenile Justice Committee remain indebted to you all. Honorable Mr. Justice Alexander Thomas, the chairman of the committee constituted to regulate and monitor the progress of the trial of cases under the PoCSO Act, and Honorable Mr. Justice Shaji P. Chali, the chairman of the Juvenile Justice Committee of the High Court, are also instrumental to the success of this collegium. I express my deep gratitude and thanks to them. I also express my gratitude to Justice Anu Madam and Mr. Justice V.G. Haru. I express my sincere gratitude to Mrs. Justice Hemalekha, Justice Ramkrishna Prasad, Justice Suryapalli Nanda, and Justice Sundar Morgan for having presented the reflections on the themes discussed. I would like to thank all our invited guests for having traveled far, near, and afar to honor with your presence and to contribute to the discussions. I am also thankful to the members of the press and the media for performing their effective role. I also take this opportunity to thank the officers of the registry and all concerned from various departments who have worked tirelessly to make this colloquium a success. I, on behalf of the High Court of Kerala, Honorable the Chief Justice, all judges, and on my own behalf, once again express deep gratitude and thanks to all of you. Jai Hind.
Thank you, my lord.
We have reached the end of this function, and I think it may be incomplete unless I make a talk from the heart. He received a lot of bouquets from many people to the committee, but unknown to most of you, the real DNA of inspiration for this is our beloved Chief Justice, Justice S. Manikumar. And the DNA of his inspiration was from the Madras High Court. Please, may I request on behalf of the committee to give a standing ovation to our Honorable Chief Justice for the It was about 8 weeks back when our RG came rushing to my room and told me that I knew whenever he comes rushing in, there's some problem. He said that Chief Justice has given this task to me and my committee to organize this program. So I wanted to dodge from it and told the RG, please tell our chief that there's no convention for the High Court to directly do it. Let this be done by the Judicial Academy. So I wanted to pass the buck to Justice Bhatti. Pat came the reply the same evening, no, this, we want to create history, it should be done by the High Court. Please, it should be done by this committee. So I had no other option but to take it up. And after due consultation with my committee members, especially Justice Charlie and my colleagues, we decided to take a break from the past. We never wanted to depend too much on the usual colloquium circuit and lecture circuit. We had a lot of guidance from the National Law University, Delhi, with whom the Indian Law Institute, of which I am a part, used to associate, have been associated for the last 4 or 5 years. The Professor Anup Surendranath, then former associate of the Project 39A, Nini Susan Thomas, who is now a Fulbright scholar and fellow of the Columbia University, and Swagata Raha. These were the 3 persons who gave us suggestions for choosing the right resource persons. It was a huge risk that we had taken because for not trotting the conventional path. And it's through their efforts and through their contacts that we could get this galaxy of wonderful people who helped us, like Kushi Kushalappa, Bharati Ali, Sraya Rosogi, and many other people. We are indeed thankful to the National Law University, the academic circuit, for helping us out in this, and all the resource persons who have done this wonderful job for making this event a grand success. The staff of the High Court, especially the registry and the Registrar General, we are depending mainly on the Kerala Judicial Academy's director, Mr. Ananthakrishnan, whose services were graciously spared to us by Justice Bhatti, the president of the academy, as the academic part to do the academic coordination work, and Devendra Kumar as a special nodal officer on the administrative side, Registrar Pradeep Kumar, PRO Arun, and the huge team of personnel who helped us out. In fact, day before yesterday, we were supposed to get this hall by about 6 p.m. We could not get it. So they started arranging this hall only from 12 midnight on Friday evening, meaning from Saturday early morning, the wee hours of Saturday early morning. They didn't have the sleep. The whole lot of officers and staff, they have given their best. We have not seen their, they have invisibly done their job. And I think let us give a standing ovation to all these wonderful people who helped us out. Otherwise, and without keeping in tune the fine-tuned separation of powers, we have ventured also to pass a resolution. All the stakeholders, especially who are not part of the judiciary, please take this idea forward. We are only focused only on one point. We didn't want to focus on too many points, so lest we may lose the laser focus. Thanks to the wonderful people from UNICEF, SPYM, and other people, we could get into this area, and we could get the Supreme Court judgment also to be relied on, so that nobody can accuse us of having strayed away from the separation of powers. Please take this forward. All the stakeholders, the Forensic Science Laboratory, the Director of Women and Child Welfare Department, the Inspector General of Police, and the other people, please take this forward. And the PoCSO and the JJ committee, we would certainly, please sit down, sorry. We would certainly take some more effort into this, and let's see that we hope that we can make a small beginning. And 3 of us in the committee and the Chief Justice, 2 of us in the committee and Chief Justice, to quote the words of Justice Vijay Raghavan, we are like the bats of the twilight. Chief Justice Manikumar and Justice Charlie and myself will be disappearing from the High Court tenure in a short time to come, and so that it's for the new generation of judges to take this forward. We hope that we have sown the seeds. It's for the future generation to take it up. Last word would be for Chief Justice Emil Sai, please.
Honorable Justice Alexander Thomas, Honorable Justice Charlie, members of the two committees, Honorable Judges who have come to this judicial colloquium from the southern states, resource persons, my dear district judiciary, dear police personnel. When I was there, I should not speak about myself, and that is why I think when Mr. Kumarasan said, so what we have done in Tamil Nadu, I think you should speak. I said, I will not. When I was there in Juvenile Justice Committee, we started one particular program. I'm not going to, speak more. We started one program with the coordination of the Madras University. They were newly recruited district munsifs. You call district munsif come magistrates here, but we call them only junior division officers. There's nothing like district munsif. And so we requested the Madras University professor of criminology. So why don't they have a course on juvenile justice and on subject related to juvenile delinquency? He said we can have a program and I'll try to speak to the Vice Chancellor. I met the Vice Chancellor and requested him, sir, this particular course is very much required in the present context because a lot of juvenile delinquents who are coming. I'm sorry to use the word delinquents, it was conflict in law. So this has to be taught at the academy, that means the police academy for the newly recruited officers, for the CWCs, doctors, and mostly for the district municipal magistrates for the reason that after 3 years, they'll be the presiding officers of the juvenile justice boards. So right from the beginning, they must know how a child grows from the childhood, when he starts committing crimes, ignorant of that it is being a crime. He doesn't know that it is a crime, but then he is into the system. So this must be taught to our officers at the beginning level. So it took about nearly 3 months. There was a deliberation, there was an inauguration program as to how to chalk this particular program. There were 30 psychologists, psychiatrists involved in the preparation of the curriculum. I just went there for a day, morning session for inauguration, but it was so interesting, the discussion. I sat throughout the day. 3 or 4 months later, the program was finalized. There were 2 courses, one a diploma course and a certificate course. The first batch, and I should say fortunately that was my last request at the head of the Judicial Academy to provide sufficient funds. Nearly 100 officers were trained with this particular diploma program, 1-year diploma program on juvenile justice and juvenile delinquency and other related issues. After the completion of this program, they were all given diploma certificates. And today, I was informed by Kumarasan that this is the 6th year which is going on by the University of Madras. And this particular course has been a sort of a program at the police academy for all the sub-inspectors who join the force. And every year, this is being extended to the doctors also, not as a diploma program, but at the academy, the doctors are also taught about this. This was there in my mind, that something I have to do for the juvenile justice and for the children here, because as many of the speakers said, the Act itself speaks about neglected children who required care and protection. So first I thought that I must have a program on this. I requested Justice Charlie, sir, why don't we conduct a program on juvenile justice? Then it came to my mind that PoCSO is also one of the very important subjects to be included, and that is why the subjects were conceived. And I'm extremely thankful to my committee judges who have deliberated. I know how it's difficult to conduct a regional program. At Petras, we have done so many regional programs and national programs also. Some of the honorable judges have come from all over this country. It's a great effort. My sincere and honest thanks to my honorable committee judges, my registry, and all the people who are assembled here to enlighten us. I requested my compeers give me the entire audio program of this. I may have to sit for at least 2-3 days after whatever you have discussed. Ask either our committee judges to redo the work once again, chalk out what are the things we have to do it, and that's how. And then after this, there must be a periodical review of what is being discussed today. It's not what is today's discussion is over. Points should be chalked out. Periodical review should be made. Thank you. I'm retaining you for a longer time. Thank you, all of you. Thanks. Thanks, Vinay. Thank you.
Photograph.
I failed to thank Honorable Justice C.T. Ravi Kumar and Justice Bhatt. Thank you, sirs. Thank you.
Thus, the Regional Judicial Colloquium organized by the High Court of Kerala has come to an end. Thank you all for making this event a memorable one. Let's raise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Every morning you would call and evening you would call.